ಆ ಕೋರ್ಟ್ ಯಾವ್ದಾದ್ರು ಅರ್ಜೆಂಟ್ ಮ್ಯಾಟರ್ಸ್ ಇದ್ರೆ ಹೇಳ್ಬೋದು. ಜಗದೀಶ್ ಏನು ಇಲ್ಲಿ ಕೋರ್ಟ್ ಈ ಕೋರ್ಟ್ಗೆ ಯಾಕೆ ಬಂದಪ್ಪ ನೀನು? ನಮ್ಮ ಕೋರ್ಟಿಗೆ ಮಗ್ಳಗಿಂದ ಏನ್ ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ? ಟೋಟಲ್ 3 matters, any five matters, any urgency?
Cell number 8 ಮೇಲೆ
8. ಏನದು?
ಅದು ಮೇಂಟೆನೆನ್ಸ್ ಇದು ಮಗುಗೆ ಫೀಸ್ ಕಟ್ಟಬೇಕಾಗಿತ್ತು ಅದರಲ್ಲಿ. ಅದರಿಂದ ಅವರು ಪೇಮೆಂಟ್ ಮಾಡ್ಬೇಕು.
ನಾಳೆಗೆ ಹಾಕಿ 15. ಎಲ್ಲೆಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿದ್ದೆ ಎಲ್ಲ ಕಡೆ ಇದನ್ನು ಮಾಡಿ. ಓಕೆ.
ಸೀರಿಯಲ್ ನಂಬರ್ 40 ಮೈನರ್.
ಓಕೆ, ವೆರಿ ವೆಲ್.
2 weeks.
2 weeks. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಹಾಕ್ತೇವೆ ನಾವು, ಅವರು ಅಲ್ಲೇ ಕೇಳ್ಕೊಳ್ಳಿ. ಎಸ್.
17 minute. Serial number 17. My colleague is not able to.
17
minute.
ಯಾಕೆ ಡೇಟ್ ಯಾಕೆ ಕೊಟ್ಟಿದ್ವಿ ನಾವು?
ಹೌದು ಮೇಡಮ್, ಅವರು ಬರಕ್ ಆಗ್ತಾ ಇಲ್ಲ. ಅವ್ರದ್ದೇನೊಂದು ಎಮರ್ಜೆನ್ಸಿ, ಮೆಡಿಕಲ್ ಎಮರ್ಜೆನ್ಸಿಗೆ has gone to his native, not able to.
ಓಕೆ, ಆಲ್ ರೈಟ್. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೋಣ.
ಆಗ್ಬೋದು.
ಓಕೆ, ಅಥವಾ ವೀಕ್ ಆಫ್ಟರ್ ನೆಕ್ಸ್ಟ್ ಅಂತ ಹಾಕೋಣ. ಓಕೆ.
Serial number 28, my lord. 28 connected matter 4. We are for respondent, my lords, and IT is 61. We are for appellant, my lords. My lords, I pray for time, my lords. We need
2019 matter.
Yes, my lords. Final hearing we need to prepare, my lords. So short adjournment can be.
ಕೊಡುವುದಾ?
Other side we had informed, my.
2 weeks at the request of. Okay.
My lords, I'll be filing a better affidavit tomorrow, my lords. I've sent it to officers. It will coming today evening, my lords. Tomorrow I'll have it done, my lords.
Compliance to be done before sunset of tomorrow.
Tomorrow, my lords.
Okay. Next.
Filed the additional affidavit.
You have filed
It is there. Lord.
May I take a short adjournment to file my formal?
Call next week. At the request of.
My lords, it was meant for objections, my lords. I filed a better affidavit in November. The respondent will have to come back on objections, my lords.
My lords, I have filed my formal objection.
You have filed your objections.
Formal objection.
Okay.
Delay of, my lords, 468 days, my lords. 474 delays.
ಏನು ಯಾವ ಪುಸ್ತಕ ಕೊಡ್ತೀರಿ?
My lords, Ravidas sir was mentioning, my lords, a book by Richard Bach, my lords, on illusions. Illusions, my lords.
Oh, very interesting book. This
Yes,
I
my
did
lords.
not know.
It was this
I
suggestion,
read
my lords.
only one poem by Ralph Waldo Emerson about illusion, which it is mentioned in autobiography of a yogi by Paramahamsa Yogananda. He has written how a poem he has written, but this I did not know.
Yes, my lords.
You give 2 books. What's the price of that book?
300 rupees.
ಒಂದು 5 ಪುಸ್ತಕ.
I'll also give one to them, my lords.
One to madam also.
Yes,
Again.
yes.
Good. But format. Hello.
My lords, in serial number 4, out of oversight, I have filed my wakalat before notice was issued to client, my lords.
All right, no issue. We'll accept your notice.
Praise for a big time.
Yeah, issue notice. Srimati so and so accepts notice. Compliance to be done within 10 days. Yes.
Lordship, appearing for the appellant. Lordship, I am submitting a short memo in this regard.
8 days ಇದೆ ಅಂತ ಒಂದು application ಹಾಕಿ.
No, Your Lordship, I am providing a certificate issued by tribunal that was communicated to us on 2nd January of Income Tax Act. Within 120 days, we have filed an appeal. Your Lordships.
Appeal is filed
Madam.
within 120 days.
Madam.
From the date copy of the impugned order was furnished to the assessee,
Yes, Your Lordships.
to the assessee. Full stop. Counsel appearing for the appellant has filed a memo producing documents in support of this view. Full stop. In view of that, Office of Shri so and so is required.
Bless Your Lordships.
Okay.
Serial number 6, I may be permitted to accept notice on behalf of.
Shri,
That's apologies, my lord. 6, I have instructed.
you appear. Okay. Yes.
Appearing for the appellant, madam.
Delay
of 3 days, madam.
notice ಹೋಗ್ಲಿ. ನೀವು ತಗೋತೀರಾ?
Take notice. Delay may be condoned.
Anumati is requested to accept notice for the revenue. First off, delay being short and explanation being plausible, application is favored and the same is condoned.
Yes.
Okay. Office objection.
Madam,
R2 was
that's
not. Is overruled. Okay.
Maybe posted for admission next week.
It may be posted.
ಏನ್ ಮತ್ತೇನು ಅಡ್ಮಿಷನ್ ಕೊಡಿ, ಅದು ಅಡ್ಮಿಟ್ ಆಗೋ ಮ್ಯಾಟರ್ ಕ್ವಶನ್ಸ್ ಇದೆ.
No, madam. Maybe posted next week, madam. It just has to be.
All week after next. Okay.
But it was recorded as 15, ITA 15 of 24, but we'll take it again, my lord.
Sorry.
Fresh steps will take.
Fresh steps to be taken. Within 1 week.
Please.
Okay. Next.
Office objection, one may be overruled, my lord.
Office objection requiring office requirement for translations is dispensed with.
IA number 2 for dispensation.
ಏನು ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ವಾ?
ಆಮೇಲೆ ಅದು ಸರ್ಟಿಫೈಡ್ ಇನ್ನೊಂದು ರಿಟಲ್ ಹಾಕಿದೀವಿ ಸರ್.
ಇನ್ನೊಂದ್ರಲ್ಲಿ ಹಾಕಿರಾ?
ಹೌದು.
Application in IA number 1 of 2025, differentiation from production of certain copies which are all
Recent disposed.
ಮತ್ತೆ ಅದನ್ನ ಹಂಗಾರೆ ಮತ್ತೆ eventually disposed of that application having been favored, dispensation as sought for is accorded.
Now I filed a memo, my lord.
Ah.
This connected matter ST has been granted in respect of the very same survey number, my lord. Been granted in that request.
ಅದ್ರಲ್ಲಿ ಕೊಟ್ಟಿದಾರ
Memo has been filed, my.
issue notice, Lebanon. What, Malesh,
Notice has to go.
notice, emergent notice.
Appear for the petitioner, my lords. We have filed an IA for amendment, my lords.
Amendment you have filed.
Please, my lords.
Your objection hakilla naru. But in amendment mother,
My lords may kindly pass over, my lords.
just tell, suppose if we give order to you,
My lords, the file is with the senior, my lords.
Is
My
it?
lords may kindly pass over. I'll take instructions, my lords.
all pass. Next. Yes, Ravi,
My lord, 39 days delay, my lord.
notice of, you accept notice. Srimati signs, accepts notice. No, delay control.
My lord, the matter requires admission, my lord.
ಅದು ಸೇಮ್
Alla, same alla. This is different.
ಏನದು ಕೊಡಿ ಕ್ವಶನ್ಸ್ ಕೊಡಿ. What are the substantial questions?
Substantial question, my lord, page number 8. My lord, can be made mainly substantively in one person's name and protectively in another person's name.
ಏನು
If the officer is not very sure, my lord, whether it has to be taxed in, my lord, whether it could be taxed between two persons, my lord. If we,
as
it
between,
is called substantive assessment.
Okay.
And tomorrow, if it is held not in this person's name, the income belongs to the other one. So I can do it protectively, but no demand will not be enforced against that person. It will be kept. So tomorrow, if it in A ought to have been taxed, not A, then my lord,
it goes to
it
B.
goes. So this is one of those, my lord.
Appeal is admitted. Two substantial questions of law that read as an ನೋಡಮ್ಮ page 8 ನಲ್ಲಿ 1 and 2. Okay.
Hearing for the petitioner, my lords. My lords, the petitioner is a Bangalore-based international call center. We had filed a consumer complaint against the respondent in this matter on 24th of April 2015. My lords, after 7 years, June 2022. And then, my lords, it's been almost 2 years, 6 months, but the judgment has not been passed by the State Consumer Commission. My lords, today, my lords, we are only seeking an explanation matter, my lords.
ನೋಡೋಣ ಅದು ಯಾವ ಕಾರಣಕ್ಕೆ ಹಿಂಗಾಗಿದೆ ಅಂತ ತಿಳ್ಕೊಬೇಕಲ್ಲ. Apex courts ordinarily within 3 months judgment should be pronounced.
Yes, my lords.
Suppose if there is fault attributable to you, we do not know. So let emergent notice go. Issue emergent notice. What is first off, petitioner, in addition to taking usual steps, shall serve copy of the petition along with all the documents on the net counsel who is represented, who represents the respondent before the
State Consumer Commission, my lords.
State Consumer Commission. It is to be done immediately.
Right, my lords.
ಎರಡು ವರ್ಷ ಇಟ್ಕೊಂಡು 2.5 ವರ್ಷ ಇಟ್ಕೊಂಡ್ರೆ ನೆನ್ಪುಳಿಯೋದು ಹೆಂಗೆ ಏನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿದೆ ಅಂತ.
Consumer complaint saying that I have to execute seal deed and register it, my lord. But it was decided the ex parte, my lord, it was sent to their old address. It was not sure the ex parte order was passed. Therefore, I filed appeal before the National Commission. Lord, it is pending consideration. But I had filed an application for stay. Initially, stay was granted subject to deposit that they want a sale deed and registration. The monetary claim is not there. My contention, my lord, before my lord, I have produced receipts for having paid about repaid 21 lakhs.
You have given for refunded 21 lakh.
How?
But despite that, how is that the consumer forum directed you to execute the sale deed?
My lord, it was the ex parte order.
It was ex parte. ಎಷ್ಟು ಕೊಡೋದಿತ್ತು ನೀವು ವಾಪಸ್ ಅವ್ರಿಗೆ?
My lord, very little is there, my lord.
Little ಅಂದ್ರೆ ಎಷ್ಟು? Little is a very elastic word in English dictionary.
My lord, actually, my lord, the entire thing is paid. Whatever he has paid.
Where have you stated?
Plus
Entire is paid.
interest also I have paid, my lord.
Where have you stated? So read one sentence that entire money is paid, nothing is due from your side. ಅಂತ ಸೆಂಟೆನ್ಸ್ ಇಲ್ಲ ಅದ್ರಾಗೆ.
My lord, one minute, just 1 minute. Lord, your lordship, kindly see page number 8 end, my lord.
Huh?
8 end, page number 8 end.
Yes.
Therefore, the
8.
Last 4 lines, my lord. Therefore, the petitioner filed an application before the modification raising condition of rupees 15 lakhs. Later written arguments were also filed before the National Commission by the petitioner. The petitioner brought to the notice of the Honorable National Commission that advance amount of
Refunded the part of amount to the respondent along with interest. That is the sentence.
Sorry,
You only have said part of the amount.
but
ನಿಮ್ಮ ವರ್ಷನ್ ಇದು.
part of that I have not stated. But
Why? You read it. Come here. Come to page 8.
yes, miss.
ಲಕ್ಷ ರೂಪಾಯಿ ಡೆಪಾಸಿಟ್ ಮಾಡಿ.
Only one request. What has happened is his entire
Sorry, issue emergent notice. Yes, interim order as prayed for, subject to petitioners together depositing a sum of rupees 5 lakh in the registry of this court as under 2.5 lakh in 2 weeks, and the interim order stands vacated. Next.
request for 4 weeks. My difficulty is his account entire around 9 lakhs is siphoned off, 9 crores is siphoned off by the bank.
ಅದೇ ಮಾಡಿ. Next. Yes.
The matter to the assessing officer, my lord. Your lordship may kindly come to page number 87, lord, para 7. Para 7, we have heard the rebel submission. Similar issue came up for the consideration in so and so case. Lordship, after extracting the above order of the tribunal, issues raised by the SSC are remitted to agreement dated so and so under which rights are granted the subsidiary, and in the light of the DTA has to make a, in view of the same, instead of following the decision relied upon by the tribunal.
You produce all that.
Yes, it has been remanded, my lord. Let your lordship kindly make observation that in view of the law laid down by the Honorable Apex Court, it has to be redone. Instead of your lordship, the tribunal has directed the assessing authority to follow the World Courier India Private Limited case. Instead of that case, your lordship can only say engineering analysis, my lord.
And such other relevant.
All contentions may be kept open of both the parties.
Revenue is in appeal. with the against the order of the income tax tribunal dated 9/12/2021, whereby assessee's appeal having been appeal in ITA number 802 Bangalore 2019.
Your Lordship, present appeal is 802. The connected matters are different numbers. First appeal, Your Lordship may dispose of. The same judgment may be followed in connected matters.
Just is all connected.
Idralli, the 18.1, 18.2, 18.3, 18.4, 18.5.
Signed so. Favored, comma. Matter has been remanded to the assessing authority for consideration of fresh in terms of apex court decision in.
Your Lordship, the tribunal followed its earlier judgment.
In terms of its own judgment in
World Courier.
in its own judgment in Messrs World Courier India Private Limited versus seven to seven, comma, 116 decided on 11 the following substantial question of law for consideration. Not a question of law. Next paragraph. Learned hearing for the assessee vehemently opposes the appeal, contending that ordinarily whether something amounts to royalty or not is a mixed question of law and facts, comma, if not a question of fact, and therefore appeal is not maintainable. First off, even otherwise he submits that when remand is made, comma, much grievance cannot be made by the revenue. First off, next. We heard the learned counsel for the parties and having perused the third view, counsel appearing for the assessee, and first up, therefore, much interference in the matter is not warranted. First. Next part. The above being said, learned counsel appearing for the panel counsel appearing for the revenue is right in telling us that subsequently decision apex court decision in
Engineering Analysis Center of Excellence Private Limited for the CIT and I will just in middle of the paragraph
reference consider
specific ಆಗಿ ಒಂದ್ಸರಿ ಹೇಳ್ಬಿಟ್ರೆ
ಇದೆ ಅಂತದ್ರಿ ಎಲ್ಲ ಬರಿಬೇಕು ಕಾಮ give liberty to the appellant canvass all the points of law.
Yes.
Including the decision.
Page number 88, Lord.
88 ನಲ್ಲಿ ಇದೆ ಅಂತ
Page number in the middle of the paragraph. Honorable Supreme Court in the case of engineering analysis.
ಅದನ್ನೆಲ್ಲ ನೋಡ್ಕೊಂಡು ಮಾಡ್ಯಾರ ಅವರು.
ಅದು ಮಧ್ಯದಲ್ಲಿ Engineering Analysis Center of Excellence Private Limited reported in 125taxman.com 42. Page number 88, Lord.
88 ನಲ್ಲಿ Engineering Analysis Center of Excellence Private Limited versus ನೋಡಮ್ಮ 88 ನಲ್ಲಿ ಮಾರ್ಕ್ ಮಾಡಿದ್ದೇನೆ. First, next part. With the above observations, appeal is disposed of. All appeals are separate matter. The subject matter of this appeal is substantially similar to the one this day decided by us in ITA number so and so, so and so. So and so, like what has been ordered in the coordinates. So, ಇದೇ ರೀತಿ ಎಲ್ಲ separate ಮಾಡಿ get some amount as fee. ಅಲ್ಲಿ 3 matters ನಲ್ಲಿ delay ಇದೆ, ಕಂಡೋನ್ ಮಾಡಿ application ಕಂಡು.
Please.
Grateful.
Have to raise another substantial question of law. ಇಲ್ಲ ಇಶ್ಯೂನೇ ಬೇರೆ ಅದು. ಅದ್ರಲ್ಲಿ ನೋಡಿದ್ರೆ ಒಂದು ಕ್ವಶನ್ ಬಿಟ್ಟು ಹೋಗಿದೆ.
ಕ್ವಶನ್ ಇದ್ರು ಸಹಿತ ಆಗಲ್ಲ. ಅಂದ್ರೆ monetary limit depends on the question.
ಕ್ವಶನ್ ಅಲ್ಲ, ಇಶ್ಯೂ what is the disputed tax?
Panel council. Call after 2 weeks ಮಾಡೋಣ. 2 weeks. So.
Section 56(2)(7)(b) says, my lord, if the shares are issued for a premium, my lord, that has to be considered for the purpose of taxation.
100 Tata company shares. And again, what rights? Rights?
If 10 rupee shares are issued for my lord,
ಇದರಲ್ಲಿ ಏನು ಮಾಡಿದ್ದಾರೆ?
ಇದರಲ್ಲಿ ಅದೇ
ಕನ್ಸಿಡರ್ ಮಾಡಬಾರದು ಅಂತ ಮಾಡಿದ್ದಾರೆ.
ಮಾಡಿದ್ದಾರೆ. 16 page number 16, my lord, I'll just take what the assessing officer has done.
What he has done.
My lord, at page number 19, he has valued the shares and the, my lord, compared to the fair market value. So the difference has been, my lord, brought to tax.
Because section reads that way.
Reads that 56(2)(b), my lord, section is called out in
This is amended in the
page number
2012.
16. My lord, from 2012.
Yes.
Page number 16 is the section, provisions of law.
For the purpose of this clause, the fair
Where
market
where a
value of
company not being a company,
the value
My
as
lord.
may be determined in accordance with such method as may be prescribed or as may be substantiated by the company to the satisfaction of the assessing officer based on the value on the date of issue of shares of its assets, including intangibles being good and meant any sum received by company in excess of fair market source. The company has to make valuation for issuing of shares. Fair market valuation of shares under otherwise obtaining market value of shares determined by a merchant banker or accountant at the discount free cash flow or may be substantial. After this brief discussion about section, it will be clear that assessee have obtained valuation report before issuing the share from merchant bank.
don't quote, but the valuation, my lord, the correct valuation has been arrived at in page number 19 by the AO.
change in the Method of valuation, my lord, adopted by the EU and adopted by the SSE.
Page number 19,
19,
paragraph.
4.11.
After the above discussion, the fair market value of the share is arrived by a consideration of the book value of the assessee and liability in the balance sheet. Audited report before the issue of share as by of the company value. So fair market value of shares, market value of the share is arrived at is assessee has issued share premium of rupees. So ಏನು ಮಿಸ್ಟೇಕ್ ಇದೆ ಇದರಲ್ಲಿ?
Valuation may not adopted with the officer.
ಕರೆಕ್ಟ್, ಎರಡು ಮೆಥಡ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
Correct.
ಅದು
That
ಒಂದು
has
method
been-
ಅನ್ನು ಉಪೇಕ್ಷಿಸಿದ್ದಾರೆ.
No, what the revenues can be.
That alone substantial question of law.
My lord, the valuation also, my lord, is given in the section, my lord.
ಏನಿಲ್ಲ.
My lord, explanation says, fair market value of the share shall be the value as may be determined in accordance with such method as may be prescribed.
ಅದ್ರಾಗಿನ್ ಎರಡು ಮೆಥಡ್ ತೋರ್ಸ್ಯಾರ, ಒಂದ್ ಮೆಥಡ್ ಫಾಲೋ ಮಾಡ್ಯಾರ ಇವರು. ವೈ ದಟ್ ನೀವು ಹೇಳೋ ಮೆಥಡ್ ಮಾಡ್ಕೊಂತ ಔಟ್ ಆಫ್ ದ ಟೂ he has chosen one method, that too normative basis. ಆ ಮೆಥಡ್ ಯಾಕೆ ತೊಗೊಂಡೇನಿ ಅಂತಾನೂ ಹೇಳಿದಾರ ಅವರು. ಏನಿಲ್ಲ, ಯಾವ ಕ್ವಶನ್ ಆಫ್ ಲಾ ಹೇಳೋದಿಲ್ಲ. ನೋಡ್ಕೊಂಡು ಹೇಳ್ತೀರಾ ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಪ್ಲೀಸ್, ನೆಕ್ಸ್ಟ್ ವೀಕ್.
Seven of 23, 682 of 23, 683 of 23, it may be called along with.
Call along. ಬರ್ಕೊಡಿ.
Hearing for the response.
ಏನಿದೆ?
Your Lordship, in this case, my lord. It may be adjourned for 4 weeks. My lord. Review petition is pending, my lord, in Supreme Court.
ರಿವ್ಯೂ ಪಿಟಿಷನ್ ಈಸ್ ಪೆಂಡಿಂಗ್.
Yes, my lord.
ಅದೆಷ್ಟು ವರ್ಷ ಹಿಡಿತು ಅಂತ ಯಾರಿಗೆ ಗೊತ್ತು?
It is likely to come up, my lord.
Call this matter after 4 weeks at the request of the panel counsel. It is likely to come up for hearing before long.
Yes, my lord.
This will have to be connected with 1216 per 23, my lords.
Call along with ಬರ್ಕೊಡಿ.
Connected matter is admitted, my lord.
Admitted.
Admitted, my lord. In the same from the arising out of the impugned order, my lord.
Appeal is admitted on the following substantial questions of law.
And also one more question has been thrown by this honorable court. Your lordship has framed it.
And
The same
also
questions has.
Additional question of law. ಯಾವ್ದ್ರಲ್ಲಿದೆ?
ಅದರಲ್ಲಿದೆ order sheet ಅಲ್ಲಿ.
Question of law, which has been framed in a connected ITA number 102 of 2024. ಇದ್ರಾಗಿನ ಕ್ವಶನ್ಸ್ ಹಾಕ್ಬಿಟ್ರಾಗತ್ತನ?
Yes, my lord. Same questions, my lord. All the 3.
3 ಆಗಲ್ಲ, 2 ಆಗಲ್ಲ.
Your lordship, I had framed 2 questions, my lord. Your lordship has framed 1 question, so totally 3, my lord.
One ಯಾವ್ದದು?
ಅದು ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಇದೆ order sheet ಅಲ್ಲಿ.
The fact of this case is substantially similar.
The last 2 lines.
Whether the fact ಅಲ್ಲಿ ನೋಡಮ್ಮ, which ಅಲ್ಲಿ appeal is admitted on the following substantial questions of law. First off, ಅದ್ರ ಕೆಳಗಡೆ one more question is also framed in ITA 102 of 2024, and therefore in the similarity of fact matrix, said question is also framed herein, and the same reads as under. Two is there. No? I could call it this along with
Your Lordship, it may be adjourned for 4 weeks, now. Same review
Alle
petition is pending.
review petition antittala 4 weeks, same order.
Lordship, transfer pricing issues are involved, my lord. It
Ah.
may kindly be admitted, my lord, since your Lordship is hearing that connect.
Nam Chaitanya argue ಮಾಡ್ತಾ ಇರೋದು.
Adene.
Chaitanya is angry
ಈಗ-
that we have been not deciding that matter. We are doing it shortly. The change ಆಗತ್ತಲ್ಲ. Change ಆದ್ಮೇಲೆ. Appeal is admitted on the following substantial questions of law. First stop, ಕೆಳಗಡೆ. We have noted ಅಂತ ಬರೀತೇವಲ್ಲ ಪ್ರತಿ ಸಾರಿ ಆ ರೀತಿ ಬರ್ತಾ ಇರ್ಬೇಕು. Okay. Yes.
Please, my lords.
Yes.
Lords, in this, there are 5 questions.
Well, we owe an apology to you
No, not at all.
because wow, I went to the Harvard and then again by that time my partner went to the Harvard after I came back
Lords, may
here.
kindly take back those words. Apologies.
In fact, ಭಾಳ ದಿವಸ ಅದನ್ನೆಲ್ಲ ಹಾಗೆ ಬಿಟ್ಬಿಟ್ರೆ ಮರ್ತು ಬಿಡ್ತೀವಿ ನಾವು ಇದರಲ್ಲಿ actually.
It's,
Sincerely we owe an apology.
no, not at all, my lords, not at all.
Okay.
We would assist my lords on any day.
That's
on
fine,
this,
that's
for sure. Lords, these questions are at page 99. There are 5 questions. Questions 3, 4, and 5, my lords, are on transfer pricing.
Admit them. Same
Therefore-
you're asking, it will have some.
Pricing,
It
so
casts a shadow, the
uh,
judgment which.
to some extent. Read out, would it have the jurisdiction? This question, my lords, will have some bearing on what answers my lords would give. Therefore, my lords, this may kindly be admitted, my humble submission. And first 2 questions do not relate to but I would pray that my lords, because last
ಅವ್ರಿಗೆ ಒಂದು ಕಾಪಿ ಒಂದು ಕೊಡ್ತೀರಿ.
my lords would be admitting. No.
Yes, admitted. ಅಲ್ಲಿ heard, let's see it to look at Mr. Chaitanya Hegde. So, yes, okay.
My lords, the issue pertains to my lords, whether the impugned good patient
21 of 20.
21 of 2002 or not, my lords.
But
My lords, it is a case of the appellant is that, my lords, the respondent, they have imported certain goods which has been used for the medical procedures, my lords, especially for the operations, wherein it is been used to
Yes.
cover up the wounds which has been operated, my lords. Surgical tape.
Huh.
This is a set classification under which the goods has been imported. My goods under which this classification has been shown, my lords. My lords, that's, I mean, the set classification is not shown in the said notification. That is the reason the
So no
goods are
exemption.
exempted. Also, my lords, insofar as the demand, my lords, it has been upheld. But insofar as the penalty is concerned, that's also, my lords, rupees 50 lakhs each, insofar as the authorized signatories are concerned, that has been upheld. My lords, the tribunal order, can you look into page 49, my lords, Annex A. 48 and 49, my lords. Para 29,
29.
please.
Ah,
I'm sorry, my lords, before that, can you look into page 46, my lords? That is where the observation starts. Page 46,
ah.
from last line, my lords, 12 lines before the last para, my lords. And on the basis of the facts, it starts. Lordship following, my lords.
Skin barrier.
Skin
microscope.
barrier, microscope, okay. Micropore surgical tape do
Ah.
not exist on the before us. We find that the product known as the impugned goods do not match the description given the used for the ostomy procedures, and it is enough if they are capable of being used. We find that to be eligible for exemption, the impugned goods need to match
As
the
the
description
description as given in the
as given in the
notification.
notification, and only
Then the question of their actual use or
use of the
capability of
please.
being used would come into play.
Please.
ಏನ್ ತಪ್ಪಿದೆ ಇದು? Suppose if it does not fit into the contemplated contours of the notification, then how
You know, the content of the notification is
no, take us to the notification and goods also, description of your goods. ಅಷ್ಟೇ ಇದೆ.
limitation. But if they are able to show that there is fraud, suppression or willful misstatement of facts, etc.,
It's extended
it's extended to 5 years.
up to 5 years.
Yes, madam. In this case, section 28, madam, I'll just hand over a compilation.
import is from 2006 to 2010, my lord. Show cause notice was
Section
issued in 11.
Off finding ಎಲ್ಲಿದೆ ಇಲ್ಲಿ?
Page 2.
Invoke that,
Page 2 of this compilation, if I may read, my lords.
place 2.
Section 28. May I read, my lords?
1 second.
Page 2, I'm sorry. May I read, my lords?
1 second. Section 28.
Section 28. Notice for payment of duties, interest, etc. Where when any duty has not been levied or has been short levied or erroneously
Erroneously
refunded, or when any interest payable has not been paid, part paid or erroneously refunded, the proper officer may, in a case of any education, research or charitable institution or hospital within 1 year, in any other case within 6 months.
ಅಲ್ಲಿ ಫ್ರಾಡ್ ಗೀಡ್ ಎಲ್ಲಿದೆ?
Allila, from the relevant date, serve a notice on the person.
Issue notice.
Notice, yes, but now comes provision.
One period is 6 months.
6 months, the normal period, the duty.
On these grounds.
Yes, my lord.
Ah,
Now
then-
the proviso, my lord. Provided that where any duty has not been levied or has been short levied or interest has not been charged or has been paid or the duty of or interest has been erroneously refunded
By reason of
by reason of
collusion or any
collusion,
willful misstatement of suppression.
confusion or any willful misstatement or suppression of facts by the importer.
Instead of 6 months, it will be 5 years.
Case,
Of finding ಎಲ್ಲಿದೆ?
the tribunal in my case held in my lord's page 49 of the impugned order that the imports have been being made of this product by me for a number of years. I have been declaring on the bills of entry, the
No, that
description.
question is not that. To contend, you are contending, the limitation period, special period of limitation of 5 years would apply because of these mens rea elements. Where is that? Where have you pleaded? Where is the demonstrability, prima facie? Show that.
My lords, it was a continuous import, my lords, from
That makes no
2006
sense.
to
That goes against
2010.
you. That goes against you.
That is the finding of the tribunal. Page 48, my lords.
ಎಲ್ಲಿದೆ?
Impugned order, page 48, paragraph 29.
Hello, where did you take up the contention of the kind before the tribunal? ಅದೆಲ್ಲಿದೆ?
Page 48, paragraph 29, my lords.
ಆದಿತ್ಯ, ಏನು ನೋಡ್ಕೊಂಡು ಹೇಳ್ರಿ ಇದೇನು? See that, what is this? To invoke special period of limitation,
My lords.
these elements are necessary. Fraud, collusion, misstatement of the dealer or his agent ಅಂತ section ಇದೆ. It's a special section.
My lords.
We understand the logic of that. Yes. Matrix.
And says it has not been invoked. The tribunal.
ಅಲ್ಲಿ ಎಲ್ಲರೂ ಆ ಸ್ಟ್ಯಾಂಡ್ ತಗೋಬೇಕಲ್ಲ ನೀವು. ಇವ್ ಹಿಂಗ್ ಮಾಡಿದಾನೆ. He is not a good man. Therefore, we have invoked this provision ಅಂತ ಎಲ್ಲರೂ ಒಂದು
Gold one matter had come, where I had produced the notice invoking 79 of the vide.
Correct.
ಆ ತರದ್ದು ಯಾವ್ದೋ ಒಂದು ಇರ್ಬೇಕು.
ಹಾ ಅಂತದ್ ಏನು ಒಂದ್ ಸ್ವಲ್ಪ ಏನಾದ್ರು ಮಾಡ್ತಾರೆ.
Like show cause notice was issued invoking the extended period.
ನೋಡೋಣ ಅಷ್ಟು ಸಿಂಪಲ್ ಇರಲ್ಲ ಒಂದೇ ಸರಿಗೆ. ಡೀಲರ್ಸ್ ಎಲ್ಲರೂ ಕೆಟ್ಟ ಅಂತಲ್ಲ, ಬಟ್ ಎಲ್ಲರೂ ಒಳ್ಳೆಯವರು ಅಂತಾನೂ ಅಲ್ಲ. ನೋಡ್ಕೊಂಡು ಹೇಳಿ ಏನಿದೆ. ಇನ್ವೋಕೆಬಿಲಿಟಿ ಆಫ್ special provision, proviso exception to the main rule. Therefore, if you want to invoke exception, the exceptional case has to be made out. The last week's matter. So sit with him and note kodi avaru ಸ್ವಲ್ಪ ಏನೋ ಹೇಳಿ. ಆ ಸ್ಟ್ಯಾಂಡ್ ಬೇಕು. ಮತ್ತೆ ಇವೆಲ್ಲ ಈ ಮೆನ್ಸ್ರಿಯಾ ಎಲಿಮೆಂಟ್ಸ್ ಇರುವಂತ ಕೇಸ್ಗಳಲ್ಲಿ ಸ್ವಲ್ಪ ಪ್ಲೀಡಿಂಗ್ಸ್ ಬೇಕು, ಸ್ವಲ್ಪ ಡೆಮಾನ್ಸ್ಟ್ರೇಬಲ್ ಎವಿಡೆನ್ಷರಿ ಮಟೀರಿಯಲ್ ಇರಬೇಕು. ಹಾಗೆ ನಿಮ್ಗೆ ಅನಿಸ್ತು ಅನ್ಕೊಂಡು ಆ ಸೆಂಟೆನ್ಸ್ ಬರೆದ್ಬಿಟ್ರೆ ಮುಗಿಯಲ್ಲ. ಅದು ಎಸ್ ತೋರಿಸ್ಬೇಕು. ನೆಕ್ಸ್ಟ್ ವೀಕ್
Has no objection, my lord, can it be next week, my lord?
ಕಾಲ್ ವೀಕ್ಸ್
For the appellant in this matter. My
ಏನಿದೆ
lord, on the last occasion,
ಹಾ.
my learned friend had given notification that it comes up below monetary limit received in instruction. Demand is only around 30 lakhs. 37 lakhs. The monetary limit is 1 lakh, 1 crore.
ಗೊತ್ತಿಲ್ಲ ಏನಿಲ್ಲ.
If your lordship passes the order, just that exceptions ಇದೆ.
ಆ ರೀತಿ ಮಾಡಿ.
Liberty may be reserved.
ಯಾವ ಮ್ಯಾಟ್ರು ಅಂತ ಬಿಲೋ ಮಾನಿಟರಿ ಲಿಮಿಟ್
Sir,
CBDT ಸರ್ಕ್ಯುಲರ್
CBIC. Exemptions it comes away.
so it comes to about 34 lakhs, my lord.
ಮ್ಯಾಟ್ರ್ ಮಾಡಿದ್ವಲ್ಲ
37.
34 lakhs, page.
ನಿಮ್ಗೆ ಗೊತ್ತಿರ್ಬೇಕಲ್ಲ.
34,
ಇದು CBDT ಬದಲಿ CBIC.
CBI.
The demand is about 34 lakhs only, so.
Liberty is
Obliged.
On behalf of Mr. Aras,
ಅರಸ್
kindly pass it over.
ಪಾಸ್ ಓವರ್. ಓಕೆ.
Even 34, remember.
32 and 34 ಎರಡು ಪಾಸ್ ಓವರ.
But this is a case where the E-sugam is generated at the
ಯಾರು ನಿಮ್ಮ ಅಪೋನೆಂಟ್?
100% rate.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಮಾಡೋಣ ಸಮ್ ಟೈಮ್.
Notification that the tribunal relies on has been superseded a number of times. And
ಸೊ ನೋ ಲಾಂಗರ್ ಇಟ್ ಈಸ್ ಇನ್ ಆಪರೇಷನ್.
what had happened, my lords, was that in 2010, when I first introduced the E-sugam, direction was given to my officers, since your duty to educate anybody, and if people come to the check post without superseded in 2011 of the same notification, after 7 years of prevalence of E-sugam, and about 10 notifications are superseded the previous one.
ಅಷ್ಟೇ ಕೇಸ್.
Ashtek case. And it is that notification is very clear. Before starting of movement of goods, the
ವಾಟ್ ಟ್ರೈಬ್ಯುನಲ್ ಸೇ?
tribunal relies on the old notification.
ಆರ್ಡರ್ ತೋರಿಸಿ.
15 to 34.
ಅಮೆಂಡೆಡ್ ಅಪೀಲ್ ಯಾಕೆ ಹಾಕಿದ್ದು? ಇದಲ್ಲ ಕೋರ್ಟ್ ಆಫ್ ಸರ್ಕಲ್ 33 ಕೊಡಿ. 34 ಅನ್ನು ಕೊಟ್ಟಿದ್ದು. ಅಲ್ಲಿ 32, 34 ಪಾಸ್ ಓವರ್ ಆಗಿದೆ. 33 ಕೊಡ್ಬೇಕು. ಇದು 34 ಇದು ನೀವು ಕೊಟ್ಟಿದ್ದು.
ಇನ್ನೊಂದು ಸ್ಟೇಟ್
ನಾನ್ ಎಕ್ಸಿಸ್ಟೆಂಟ್ ನೋಟಿಫಿಕೇಶನ್ ಅನ್ನು ಆಪರೇಟ್ ಮಾಡಿ ಅಷ್ಟೇ ಕೇಸ್ ಅಷ್ಟೇ. ಬರ್ಕೊಳ್ಳ. This revision by the state filed under section 65(1) of KVAT Act 2003 seeks to call in question state appellate tribunal's order whereby assessees STA number 377/2018 having been favored, relief has been accorded to him. First, as under page 34.
This is the notification which superseded 24/5/2010.
Okay.
And the next is the notification that
One
was,
second.
was in force in 2017 when the interception has occurred. Clearly saying that, that the E-sugam has to be generated before movement of goods.
Next. Learned counsel appearing for the AGA appearing for the state submits that was done away with by issuing subsequent notifications dated 5/3/2014, correct?
Ultimately 5/3/2014, but if your lordship see 19/1/2011, that itself
Dated 19/1/2011, 19/1/2011, followed by ultimately the one dated 5/3/2014. First, assessee has remained unrepresented despite service of notice, and that would not deter the court from deciding the cause brought before it. First, next one. Having heard the learned AGA and having perused the petition papers, we are inclined to grant indulgence in the matter in as much as the subject notification based on which the impugned order has been structured was not because of subsequent notifications that held the field. First, thus there is error apparent on the face of the record that would give rise to the questions of law. Framed in the petition. First, in the above circumstances, the set it not. First, as a consequence, ಯಾವ order restore ಆಗ್ತದೆ?
That's the assessment order. Another aspect is, my lord, he says that
penalty could not have been levied. The court has held that the 53 is mandatory. In power max.
Notifies to the decision of this court in so and so, wherein it is held that imposition of penalty is a matter of mandate, and therefore the authorities do not have any discretion to disobey the same. First, in view of the above petition, and so iddan notkondu maatadi. Okay, a judgment for 2012, 2011 SCC online Karnataka 460. ಗೊತ್ತಾಯ್ತಾ? Instruction ಮಾಡಬೇಕು. The following questions of law ಅಂತ ಹಾಕೊಂಡು ಆ questions ಅನ್ನು raise ಮಾಡಿ. consequence. As a consequence, ಯಾವ order revive ಆಗುತ್ತೆ? As a consequence, the order impugned before. Next.
Kindly.
ತಿರುಮಲೇಶ್ ಬಂದಿಲ್ವಾ ಇವತ್ತು? ಏನು ಕಾಮನ್ ಆಗಿ he will not miss. Call next week to enable counsel for the appellant to come. Okay. Pass over.
38 is a, privilege is appearing very short question of law. Facts are admitted. This matter, if your lordships may have tomorrow.
All right. Tomorrow.
Because Mr. Tirumalesh said he's back tomorrow.
To enable counsel for the respondent to assess to come. Yes. Start. Your friends can go for a coffee round perhaps. But pass over ಮಾಡಬೇಕಾ?
I'll just, ಯಾಕಂದ್ರೆ batch ಇದೆ.
Okay. ಎಲ್ಲ identical questions of law na?
Except one.
In I'm instructed in 5P30 of 2023. One question frame wouldn't arise from the impugned order. So
If question is not decided and we have interpreted it, that question arises, but the tribunal does not raise it.
it is not even a matter.
Will not
before-
arise at all.
It doesn't even arise from the lower orders.
All right. Pass. ಒಂದು ಅರ್ಧ ಗಂಟೆ ಬೇಕಾಗತ್ತಾ ಅಥವಾ ಮಧ್ಯಾಹ್ನ ತಗೋತೀರೋ? ಹೆಂಗ್ ಮಾಡ್ತೀರಿ?
ಮಧ್ಯಾಹ್ನ ಆದ್ರೆ we'll
Ah.
finish it.
Would take it to 2:30?
Yes, 2:30 ಬನ್ನಿ. ಆಗ್ಲಿ. Okay. ಬಸವರ ಮೆಟ್ಟ ಬೇಕಾದ್ರೆ ಈಗ ಕರೆದು ಬಿಟ್ರೆ ಆಗುತ್ತೆ. 2:30 ಬನ್ನಿ. So that Aditya also batch of matters ಇರೋದಕ್ಕೆ.
Yes, yes.
Okay.
One matter appears for the petitioner.
Ah.
In the other matter, my lord, Mr. Narasimha Swami, he appears for the petitioner, censorship board.
Ah.
Where, my lord, on the ground of the question, my lord, whether a director or the member secretary who is competent on that issue, my lord, I succeeded in one matter. Mallikarjun, that is 7144 is concerned, WP. There, my lord, what happened, the employee was working in the censorship board. He was posted to work in a particular unit. As far as he is concerned, my lord, 1995, my lord, he was placed under suspension on certain allegations. Accounts were not properly maintained and all that. There were several, 3 or 4 charges. He submitted reply denying the allegation.
Yes.
Retired district was appointed as the inquiry officer who conducted the CGIT. Then, my lord, what happened? This he being a workman category, raised a dispute, and the matter came up before the CGIT, Central Government Industry Tribunal. There was a preliminary issue with regard to fairness of the domestic inquiry.
Compulsory retirement amounts to dismissal and
dismissal. Therefore, 2A is attracted. Then, my lord, inquiry is held to be fair.
Oh, it was held to be fair.
Fair.
Therefore,
but only thing on evidence. At that time, my lord, I also amended the claim statement, contending that, my lord, in my case, the order of compulsory retirement and the initiation of disciplinary proceedings is by the director. Director is not competent, it is a member secretary. Central board, as far as Central board is concerned, the head of the unit is member secretary. He is my appointing authority. Board is a Ministry of Textiles. It is attached.
It's a government company as defined under section 617 of the Companies Act, or it is a statutory corporation.
Statutory corporation.
Statutory corporation.
Statutory corporation.
Allonದು act ಇದೆಯಾ?
Central board act ಇದೆ. ನಾನು ಕೊಡ್ತೇನೆ. So ಅದರೊಳಗೆ ಏನಾಯ್ತು ಅಂತಂದ್ರೆ, then what happened? On that those 2 cases were held to be, my lord, without competency. On that issue, my lord, I succeeded before the trial. Holding that, my lord, since he has already attained the age of superannuation long back, question of reinstatement does not arise. However, we mold the relief by granting 80% back wages. Since he is compulsory retirement, my lord, it's a case of getting some pensionary benefit, he is getting it. But with regard to back wages, they said 80%. I mean, full back wages, that is my. And in the case, on the ground from service, in her case also, I took up the very same.
Without jurisdiction.
Aduna, honorable judge rejected it.
If the order is held without jurisdiction,
yes,
what would follow? That needs to be given to you is your contention.
Yes.
Okay.
And this one, long back I retired from service, remanding the matter Baralanta tribunal. That appears to be very reasonable and fair. 80% ಕೊಟ್ಟಿದ್ದಾರೆ. Then I told my letter friend also. Already, if you are agreed by the Rajasthan Jal Samsthan case, Honorable Justice Santosh is 50% ಅಂತ ಹೇಳಿದ್ರು.
ಈಗ ಎಷ್ಟು ವರ್ಷ ಅವ್ರಿಗೆ?
Yes, ma'am.
What is the age of these people.
Now, my lord, he is age. Just 1 minute.
Not good. ಒಂದೇನೋ ಒಂದು ಪ್ರಿನ್ಸಿಪಲ್ ಮಾಡ್ಕೊಂಡು ಮುಗಿಸ್
ಬರ್ಬೇಕು ನರಸಿಂಹಸ್ವಾಮಿ ಸಲ ಹಿಂದೆ ಟೈಮ್ ತಗೊಂಡಾಗ ಅದಕ್ಕೆ ರೆಕಾರ್ಡ್ಸ್ ಬಂತು, ಜಡ್ಮೆಂಟ್ಸ್ ಎಲ್ಲ ಫೈಟ್ ಮಾಡಿ ಅಂದ್ರು, ಅದನ್ನು ಹಾಕಿದ್ರು.
ನಾವು ಅವ್ರಿಗೆ ವೇಟ್ ಮಾಡ್ಕೊಂಡು ಕೊಡಕ್ಕಾಗಲ್ಲ.
ನಾವು ಯಾವತ್ತಾರು
ಇಷ್ಟೇ ಕೇಸ್
ಇಷ್ಟೇ.
ದಟ್ಸ್ ಆಲ್. ಮತ್ತೆ ಆರ್ಗ್ಯುಮೆಂಟು ಇಲ್ಲ, ಕುತ್ಕೊಂಡ್ಬಿಡಿ, ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡ್ಬಿಡ್ತೇನೆ. ಏನಾದ್ರು
ಬ್ಯಾಕ್ ವೇಜಸ್ ಇದ್ರೊಳಗೆ ನಾನು ಏನಿದೆ ನಾನು ಹೇಳ್ಬಿಡ್ತೀನಿ ತಾವು ಮೇ ರಿಕ್ವೆಸ್ಟ್ ನನ್ನ ರಿಪಿಟಿಷನ್ ಒಳಗೆ ಎರಡರಲ್ಲೂ ಒಂದೇ ಇದೆ ಬಿಡಿ ಅವಾರ್ಡು. ದಯವಿಟ್ಟು ಒಂಚೂರು ಅವಾರ್ಡ್ ನಲ್ಲಿ ಇಷ್ಟೇ ರೀಸನ್ ಪ್ಯಾರಾ 11 WP 7144 ಅವಾರ್ಡ್ ಇಂಪ್ಯೂನ್ಡ್ ಅವಾರ್ಡ್ ಲಾರ್ಡ್ಶಿಪ್ ಗೆಟ್ಸ್ ಇಟ್.
ಅಲ್ಲ, ಆನ್ ವಾಟ್ ಬೇಸಿಸ್ 80%?
ಅಲ್ಲ, ಅದಕ್ಕೆ ಬಂದೆ, ಅದಕ್ಕೆ ಇಷ್ಟೇ Para 12. ಹೋಗ್ಬಿಡ್ತೀನಿ. Next that may be awarded in favor of the first party consequent upon the finding as above to the referred. Now he has crossed the age of superannuation. Shall not be any liberty to the second party to revisit the disciplinary action on the same set of allegation. He should be monetarily compensated. In of the service lost due to the illegal punishment and the suspension.
Illegal ಅನ್ನಕ್ ಬರಲ್ಲ, ಅನ್ನಕ್
95 because 95 suspension ಮಾಡಿ further alleged to have
aspect. But guilt as such remains with you. It remains with you.
ಸರ್ವಿಸ್ ಅಲ್ಲಿ ಇದ್ರಲ್ಲ, ಸರ್ವಿಸ್ ಇನ್ನೂ ಇತ್ತು ಅಂತಂದ್ರೆ ರಿಮ್ಯಾಂಡ್ ಆಗಿ ಮತ್ತೆ ಐ ವಾಸ್ ರಿಕ್ವೈರ್ಡ್ ಟು ಫೇಸ್ ದಿ ಡಿಸಿಪ್ಲಿನರಿ ಎಂಕ್ವೈರಿ ಅಗೇನ್ ಅಂಡ್ ಆಲ್ ದಟ್.
Your client is not a man with clean heart, clean head and clean hands.
ತಾವು ಅದನ್ನ ಮೌಲ್ಡ್ ಮಾಡ್ಬೇಕಷ್ಟೇ. 81 ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ತಮಗೆ ಗೊತ್ತಿದೆ, ಗುಜರಾತ್ ಸ್ಟೀಲ್, ವಾಟ್ ಹೈ ಕೋರ್ಟ್ ಕ್ಯಾನ್, ವಾಟ್ ಲೇಬರ್ ಕೋರ್ಟ್ ಕ್ಯಾನ್ ಡು, ದಿಸ್ ಆಲ್ಸೋ ದಿಸ್ ಕೋರ್ಟ್ ಕ್ಯಾನ್.
ಇಲ್ಲ, ಏನು ಕೊಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ.
ಅದು ಏನ್ ಕೊಡ್ಬೇಕು
ಯಾಕಂದ್ರೆ ಕೊಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. ಅಲ್ಲಿ ಫ್ಯಾಕ್ಟ್ ಗಿಲ್ಟ್ ಉಳಿತದೆ, ಅದಕ್ಕೆ
ಇಲ್ಲ
ಗಿಲ್ಟ್ ಉಳಿದು ಬಿಡ್ತದೆ,
ಇಲ್ಲ
ಫ್ಯಾಕ್ಟ್ ಫೈಂಡಿಂಗ್ ಉಳಿದು ಬಿಡ್ತದೆ. ಅದ್ರ ಮ್ಯಾಲ್ ಮಾಡಿದ ಆರ್ಡರ್ ಅಷ್ಟೇ ಹೋಗ್ತದೆ, ಬಿಕಾಸ್ ಇಟ್ ಈಸ್ ವಿದೌಟ್ ಜ್ಯೂರಿಸ್ಟಿಕ್ಷನ್ ಅನ್ನೋದಕ್ಕೆ. ವಿದೌಟ್ ಜ್ಯೂರಿಸ್ಟಿಕ್ಷನ್ ಇಸ್ ಎ ನಲಿಟಿ.
ಅದಕ್ಕೋಸ್ಕರ
that is the reason. But fact of guilt, that finding remains.
What happened, my lord? May I make one submission?
Head.
May I make? ಇದೇನಾಯ್ತು ಅಂತಂದ್ರೆ, ಸಿನ್ಸ್ my lord, even though enquiries had to be not fair and proper, since my lord I succeeded in the other issue.
ಅಲ್ಲ,
only
say
half a minute.
you gave up that contention.
Yes.
You gave up that contention. I have read the papers.
Yes, yes.
You gave up the
Half a
contention
minute, my lord. Yes, yes.
whether the inquiry is properly held.
ಹೌದು.
ಅದು it attained finality.
ಅದ್ರೊಳಗೆ ಏನಾಯ್ತು ಅಂತಂದ್ರೆ, ಇದು ರಿಟೈರ್ಡ್ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಜಡ್ಜು ಎನ್ಕ್ವೈರಿ ಮಾಡುವಾಗ he was more than 70 years. ಆ CCS ನೊಳಗೆ more than 65 years ಇದ್ರೆ ಎನ್ಕ್ವೈರಿ ಆಫೀಸರ್ನ ಅಪಾಯಿಂಟ್ ಮಾಡಬಾರ್ದು.
ಅವಾಗ
ಆ ಪಾಯಿಂಟ್ ಅರ್ಜಿ ಮಾಡಿದೆ ನಾನು, ಬಟ್ ದಟ್ ವಾಸ್ ನಾಟ್. ಅಲ್ಲ ನಾನು ಏನಿದೆ ಫ್ಯಾಕ್ಟ್ಸ್ ಹೇಳ್ಬೇಕು ತಮ್ಮ ಮುಂದೆ.
ಅಲ್ಲ,
ಅಲ್ವೇ?
ಅದು rules ಎಲ್ಲ are
ತಪ್ಪದು.
held to be directory by the Supreme Court.
ಡೈರೆಕ್ಟ್ರಿ ಆಯ್ತು, ಆಮೇಲೆ ತಪ್ಪು
Once ಆಗಿದೆ,
ಇಲ್ಲ, ತಗೊಂಡು-
ಇದೆ, ಇವ್ರಿಗೆ ಇಂತ ಕೇಸನ್ನು ಡಿಸೈಡ್ ಮಾಡಕ್ ಆಗಲ್ಲ, ನಾವು ಬೇರೆ ಜಡ್ಜ್ ಯು ಶುಡ್ ಹ್ಯಾವ್ ಕಾಲ್ಡ್.
maybe otherwise also. Because of that age, he may be a very experienced person. Maybe, ಅದು ಇರುತ್ತೆ, ನಾವು ಇಲ್ಲ ಅಂತ ಹೇಳಕ್ ಆಗಲ್ಲ. ಕೆಲವೆಲ್ಲ ನನಗೂ ಗೊತ್ತಾಗುತ್ತೆ, ಬಟ್ ಗಿವಿಂಗ್ ಅಪ್ ದಿ ಎಂಟೈರ್ ಬ್ಯಾಕ್ ವೈಸ್ ಇಲ್ಲ ಅಂತ ತಪ್ಪಾಗುತ್ತೆ. ತಾವು ಸ್ವಲ್ಪ ಕೊಡ್ಲೇಬೇಕಾಗುತ್ತೆ. ತಾವು ನೋಡಿ
ಅದು ಗಿಲ್ಟ್ ಹಂಗೆ ಉಳಿದು ಬಿಡುತ್ತದೆ.
ಅಲ್ಲ, ಇಲ್ಲ.
ರಿಮೇನ್ಸ್ ಇಂಟ್ಯಾಕ್ಟ್.
But anyway, my lord, now on the other issue I have succeeded. What should happen? And
Lordship may kindly say 95 ಒಳಗೆ suspension ಮಾಡಿ. Charge sheet was issued during 2002. 7 years I was kept under suspension. 7 years.
ಅವಾಗ ಸಬ್ಸಿಸ್ಟೆನ್ಸ್ ಅಲೋನ್ಸ್ ಬಂದಿದೆ.
ಏನೊಂದು 25% ಕೊಟ್ಟು ಆಮೇಲೆ 50 ಮಾಡಿ ನಿಲ್ಲಿಸ್ಬಿಟ್ರು ಅಷ್ಟೇ. ಅದು ಇಲ್ಲ ನನಗೆ ಆ ಪೀರಿಯಡ್ ಏನಾಯ್ತು ನೋಡಿ ಮೈ ಲಾಸ್ಟ್ ಬಿ ಕೈಂಡ್ಲಿ ಅಪ್ರಿಷಿಯೇಟ್ ಒನ್ ಮೋರ್ ಥಿಂಗ್. ವಾಟ್ ಹ್ಯಾಪನ್ ಮೈ ಲಾರ್ಡ್ 95 to 2002ಗೆ ಡಿಸ್ಮಿಸ್ ಕಂಪಲ್ಸರಿ ಟ್ರೀಟ್ಮೆಂಟ್ ಮಾಡುವಾಗ ಆ ಪೀರಿಯಡ್ ಯಾವುದು ಕೌಂಟ್ ಮಾಡಲೇ ಇಲ್ಲ. ಐ ಕುಡ್ ನಾಟ್ ಗೆಟ್ ದ ಗ್ರಾಜ್ಯುಯಿಟಿ ಅಮೌಂಟ್ ಈಗ ಸಸ್ಪೆನ್ಷನ್ ಅಂತ. ಆ ಪೀರಿಯಡ್ ಯಾರು ಆನ್ ಡ್ಯೂಟಿ ಅಂತ ಮಾಡಬೇಕಾಗುತ್ತೆ ತಾವು. The whole entire period my lord up to service with all consequential benefits, then back wages ತಮಗ್ ಬಿಟ್ಟು. ಬಟ್ ಪೂರ್ತಿ ಇಲ್ಲ ಅಂತಂದ್ರೆ ಸ್ವಲ್ಪ ತೊಂದರೆ. What I ಅಲ್ಲ that may kindly be examined. That may you last may kindly examine that. ತಾವು ತಕ್ಷಣ ಹೇಳಬಿಟ್ರಿ ಜೈಪುರ್ ಜಲಸಂಸ್ಥೆ ಹೇಳಿದ ತಕ್ಷಣ ಹೇಳಿದ್ರಿ ಎರಡು ಕಡೆಗೂ ಹೇಳಿದ್ರಿ ತಾವು. But other, my lord, it's a case where you should not be, my lord, delayed entire portion of compulsory retirement and the lordships are aware, my lord, even that even pensionary benefit is also reduced. Alladu ನನಗೆ ಸೇವ್ ಆಗ್ಬೇಕಲ್ಲ.
ನೀವೀಗ ಆರ್ಗ್ಯೂ ಮಾಡ್ತಾ ಇರೋದು ಮಲ್ಲಿಕಾರ್ಜುನನ್.
ಅಲ್ಲ ಅದರೊಳಗೆ lordship may kindly appreciate compulsory retirement, my lord, I'll get pensionary benefit but not at the rate for on which, my lord, the other employees exit ಆದಾಗ honorable exit and all that they will.
ಅಲ್ಲ
ಅಲ್ಲೂ ಕಮ್ಮಿ ಆಗುತ್ತಲ್ಲ ನನಗೆ.
ಕಂಪಲ್ಸರಿ ರಿಟೈರ್ಮೆಂಟ್ ಮಾಡಿದ್ರು.
ಹೌದು.
ಪೀರಿಯಡ್ ಕ್ವಾಲಿಫೈಯಿಂಗ್ ಸರ್ವಿಸ್ ಆಗಿತ್ತಾ?
ಎಸ್ ಆಗಿತ್ತು. ಕ್ವಾಲಿಫೈಯಿಂಗ್ ಸರ್ವಿಸ್ ಇತ್ತು. ಕ್ವಾಲಿಫೈಯಿಂಗ್ ಸರ್ವಿಸ್ ನೋ ಪ್ರಾಬ್ಲಮ್. ದೇರ್ ಇಸ್ ನೋಬಡೀಸ್ ಕೇಸ್. ಐ ಆಮ್ ಗ್ರೇಟ್ಫುಲ್ ಟು ದ ಲಾರ್ಡ್ಶಿಪ್ಸ್ ಆನ್ ದಟ್ ಪಾಯಿಂಟ್ ಬಿಕಾಸ್ ಮೈ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ 1983 20 ವರ್ಷ ನಾನು ಕಂಪಲ್ಸರಿ ರಿಟೈರ್ಮೆಂಟ್ ಮಾಡಿದಾಗ last may kindly say it was during the year 2005, 22 years. 22 years of service. Qualifying service is
93.
83 in the 2005. 83. 83 appointment. Reader, spinner anta. Regular selection ittu. Adrolaga I got appointed as a lower division clerk. Lower division clerk ಮಾಡ್ತಾ ಇರುವಾಗ this suspension last may kindly say 95 suspension ಮಾಡಿ 7 years my lord they did not initiate disciplinary proceedings. 7 years. Charge sheet ಕೊಟ್ಟಿದೆ 2002. 15/11/95 was kept under suspension pending disciplinary inquiry. 10th June 2002 my lord charge sheet came to be issued. Memorandum ಅಂತ ಕರೀತಾರೆ issued. Then the inquiry officer appointment 2005 was compulsory retired.
Date of appointment
my lord 30th November 1983.
ಏನಂತ?
As a lower division clerk.
LDC.
I'm sorry, my lord. I'm sorry. As a reeler cum spinner, technical worker.
Reeler REELER na?
Or EELER. Stroke spinner. Then, my lord, while in service, I was selected for the post of lower division clerk on 26/11/1991.
Selected, appointed.
A selection, internal selection ಇತ್ತು ಅದರೊಳಗೆ I was selected.
ಮುಂದೆ ಅಪಾಯಿಂಟ್ ಆಯ್ತಾ?
ಅಪಾಯಿಂಟ್ ಆಯ್ತು ಅವತ್ತೆ 26/11/91 ಅವತ್ತೆ
ಪ್ರಮೋಟೆಡ್.
ಹೌದು, ಸಾರ್ಟ್ ಆಫ್ ಎ ಪ್ರಮೋಷನ್ 26/11/91
as
a lower division clerk.
LDC.
26/11/91 LDC, correct.
All right.
15/11/95 suspension pending inquiry. 15/11/1995. 10th June 2000
Subsistence allowance
ಕೊಟ್ಟಿದ್ದು ಅವತ್ತಿನ 50% ಏನೋ ಕೊಟ್ಟರಂತೆ ಅದು ಹೇಳಿದ್ರು. ಆ ಪೀರಿಯಡ್ ಬಹಳ ಇಂಪಾರ್ಟೆಂಟ್ ನಮ್ಗೆ ಅವಾಗ ಆನ್ ಡ್ಯೂಟಿ ಆಗದಾಗ ಕಷ್ಟ ಆಗುತ್ತೆ. 10th June 2002 June 2002, 6/2000. Then straight away I will come to that. After inquiry and all that, date of compulsory retirement.
Charge memo dated
10th June 2002. 10th June 2002.
D held.
Fair and proper. I'll come to that. Just 1 minute, my lord. ದೆನ್ ಕಂಪಲ್ಸರಿ ರಿಟೈರ್ಮೆಂಟ್ 11/10/2005.
ಅಲ್ಲ ಅದನ್ನ ಅದು ಮುಂದೆ ಆಮೇಲೆ ಬರುತ್ತೆ. ಡಿ ಆತ ಇಲ್ಲ.
ಡಿ
ಬೈ ದ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಜಡ್ಜ್.
ಹೌದು, ಬೈ ದ ರಿಟೈರ್ಡ್ ಡಿಸ್ಟ್ರಿಕ್ಟ್. ಅವರಿಂದ after showcase notice, I was compulsorily retired on 11th October 2005. Showcase notice ಕೊಟ್ಟರು ಎಂಕ್ವೈರಿ ರಿಪೋರ್ಟ್ ಜೊತೆಗೆ. I submitted reply. Well, all that date may not be required, but 11/10/2005 is the relevant date.
ಸೊ ಶೋಕಾಸ್ SCN ಕೊಟ್ಟಿದ್ದೆ ಯಾವಾಗ? ಡೇಟ್ ನಿಮ್ಮ ಸೆಕೆಂಡ್ ಶೋಕಾಸ್ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದೆ ಯಾವಾಗ?
ಸೆಕೆಂಡ್ ಶೋಕಾಸ್ ನೋಟಿಸ್ 23/6/2005.
ರಿಪೋರ್ಟ್ ಡೇಟೆಡ್?
Report is dated 4th April 2005. 4th April. 4th April 2005, inquiry officer's report was given.
Yes.
23rd June 2005, showcase notice was given.
ಆರ್ಡರ್ ಆಫ್ ಪನಿಷ್ಮೆಂಟ್ ಹೇಳಿ.
11/10/2005. Compulsory retirement. 11th October 2005.
'83 to 2005.
Yes.
22 years ಆಗ್ತದೆ.
ಹೌದು.
Compulsory.
Sorry. I'm sorry, man.
This
Usually ಇರ್ತಾರೋ ಇದ್ರೆ ಕೇಳಿ ಹೇಳ್ಬಿಡ್ತಾರೆ.
ಹೇಳಿ. This you challenged before the CJIT.
ಅದು I raised a dispute.
ಏನದು ID?
CR central reference.
ಸೆಂಟ್ರಲ್ ರೆಫರೆನ್ಸ್.
Central reference CR.
ಇದು 10-4 ಆಗತ್ತ?
ಅಲ್ಲ, ಅಲ್ಲಿ 10-4 ಇಲ್ಲ. CJIT ಸೆಂಟ್ರಲ್ ಗವರ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇಲ್ಲ. So I raised a dispute. Conciliation failed. Thereafter, government referred the dispute.
CR
ಹೌದು.
ನಂಬರ್?
CR date. Award date ಇದೆ.
The tribunal CJIT held.
Yes.
That inquiry is properly held ಅಂತ finding ಯಾವತ್ತು?
Just 1 minute, madam. That date also I'm required to give. Just 1 minute. Yeah. I'll give the date in 1 minute, my lord. In the meantime, well, 1 minute. Yes, 1 second, my lord. Right now, I'm not getting that. I'll give it, my lord.
ನೋಡ್ಕೊಂಡು ಹೇಳಿ.
ಕೊಡ್ತೀನಿ.
Within 5 minutes we are reverting.
Yes, and then, my lord, yes. ಹೇಳ್ತೀನಿ.
ಇಷ್ಟೊತ್ತವರೆಗೂ ಕೂಲ್ ಆಗಿರ್ಲಿಲ್ಲ.
ಆಲ್ ಬಿಟ್ಟು ಇರ್ಲಿ ಬಿಡಿ, ಅದು ಅದನ್ನ ಹೇಳಿ, ಇಂಪ್ಲಿಮೆಂಟ್ ಆರ್ಡರ್ ಡೇಟ್ ಹೇಳಿ.
Compulsory retirement ಆದ್ಮೇಲೆ when I raised a dispute
ಹಾ
on 21st/11/2008,
ಹಾ
government referred the dispute. Andre, immediately after retirement, I did not delay the process. Immediately I raised a dispute. On 21/11/2008, it was referred to the central government tribunal.
ಇಮಿಡಿಯೇಟ್ಲಿ ಅಂದ್ರೆ ಯಾವತ್ತು ನೀವು ರೆಫರ್ ಮಾಡಿ?
2007 ನನಗೆ termination, compulsory retirement.
11/10/2005.
5/1/2007.
7 ಏನದು?
ಅಲ್ಲ, ಕಂಪಲ್ಸರಿ ರಿಟೈರ್ಮೆಂಟ್ ಆಗಿದ್ದು
5/1/2007.
ಹೌದು.
ಬಟ್ ಯು ಸೆಡ್ ಕಂಪಲ್ಸರಿ ರಿಟೈರ್ಮೆಂಟ್ 11/10/2005.
ಅಲ್ಲ,
ನೀವೇ ಹೇಳಿದ್ ಬರ್ಕೊಂಡು.
11/10/2005, sorry. 11/10/2005.
Yes.
That my lord, I raised a dispute. After failure of conciliation.
When did you raise the dispute?
2005, 2000.
ಎಲ್ಲಿದೆ
ಅದು
ತೋರಿಸಿ.
ಇಲ್ಲ, ರೆಫರೆನ್ಸ್ ಆಗಿ ಡೇಟ್ ಮಾತ್ರ ಇದೆ ನಾನು.
ನೀವು ಲೇಟ್ ಆಗಿ ರೆಫರ್ ಮಾಡಕ್ ಕೇಳಿದ್ರಿ.
ರೆಫರೆನ್ಸ್ ಆರ್ಡರ್
ತೋರಿಸಿ.
ರೆಫರೆನ್ಸ್ ಡೇಟ್ ಹೇಳಿದೆ.
ಆರ್ಡರ್ ತೋರಿಸಿ. ರೆಫರೆನ್ಸ್ ಆರ್ಡರ್ ನಲ್ಲಿ ರೆಫರ್ ಆಗಿರುತ್ತೆ ನಿಮ್ಮ ರೆಪ್ರೆಸೆಂಟೇಷನ್. Show that.
So refer the following industries. Yes.
Where is your letter seeking reference?
ಅದು ಇಲ್ಲ ಇದರೊಳಗೆ.
That is a decisive factor. In Tangabalu, Supreme Court said, where the workman has belatedly sought for reference, he cannot seek the back wages ಅಂತ hold ಮಾಡಿದ್ರು.
Delay on the question of delay. But ಇದು
5 April 2005 compulsory retirement. Sorry, October 2005 compulsory retirement ಆಗಿದೆ. Not immediately wasting without any time. Wasting no time. I immediately rushed to the central government, sought for reference. Reference ಇರಲಿಲ್ಲ. Straightway you could reference ನಲ್ಲೂ time waste ಮಾಡಿದ್ದೀರಿ. ಯಾಕೆ? You can straightway go and hold ಮಾಡಿದ್ದಾರೆ latest judgment of the apex court. It's set up compulsory retirement.
I follow my lord. But ನಾನು may I make one submission? May I make one submission? ನಾನು when I raise a dispute ಅಂತ ಅನ್ನೋದಕ್ಕೆ ಡೇಟ್ ನಾನು ಖಂಡಿತ ನಾನು ನಿಮಗೆ ಕೊಡ್ತೀನಿ. ಅದಕ್ಕೊಂದು ಚೂರು ನಂಗೆ ಟೈಮ್ ಕೊಟ್ಬಿಟ್ರೆ ನಾನು ಖಂಡಿತ ಅದನ್ನು ಕೊಡ್ತೀನಿ.
ಟೈಮ್ ಕೊಡುದೇ ಇಲ್ಲ ನಾನು, ನಿಮ್ಗೆ ಗೊತ್ತಿದೆ ನಮ್ಮ ನೇಚರ್. ನೋ ಇನ್ಸ್ಟಾಲ್ಮೆಂಟ್. ಹಿಂಗ ಒಂದು ದೇವ್ರು ಭಗವಂತ ಏನ್ ಹೇಳ್ತಾರೆ ಕೊಡ್ತೇವೆ.
ಅಲ್ಲ 2000, just 1 minute, man. 21/11/2008. Then you will ask. That is
conciliation
date of retirement here.
ಕನ್ಸಿಲಿಯೇಷನ್ ಆಯ್ತು ಅಂತ ಅನ್ಕೊಂಡು ಹೇಳಿದ್ರೆ ಎಲ್ಲಿದೆ ಕನ್ಸಿಲಿಯೇಷನ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್?
Proceedings ಅದೊಂದು ಡೇಟ್ ಇಲ್ಲ.
ಎಲ್ಲಿರೋ ರೆಫರೆನ್ಸ್ ತೋರಿಸಿ. ಕನ್ಸಿಲಿಯೇಷನ್ ಆಗಿತ್ತು ಅನ್ಕೊಂಡು ಎಲ್ಲಿ ಅಬ್ಸರ್ವೇಷನ್ ಎಲ್ಲಿದೆ?
ಅಲ್ಲ, ರೆಫರೆನ್ಸ್ ಒಳಗೆ ಅದು ಹೇಳೋದಿಲ್ಲ.
ರೆಫರೆನ್ಸ್ ಬೇಡ, ಜಜ್ಮೆಂಟ್ ನಲ್ಲಿ ಹೇಳಿ.
ಜಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇಲ್ಲ, ಬರಲಿಲ್ಲ.
ಮತ್ತೆ ಎಲ್ಲಿ ನಿಮ್ ಪ್ಲೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ ಹೇಳಿ. ಪ್ಲೀಡಿಂಗ್ಸ್
ಇಲ್ಲ.
ಕನ್ಸಿಲಿಯೇಷನ್ ಆದ್ರೆ 11/5 ರಿಪೋರ್ಟ್ ಬರ್ತದೆ.
ಹೌದೌದು,
ಕನ್ಸಿಲಿಯೇಷನ್ ಫೇಲ್ಡ್ ಅಂತ. ಹೌದಾ? ಎಲ್ಲರ ಒಂದ್ ಕಡೆ ರೆಫರೆನ್ಸ್ ಬರ್ತದೆ. ನಮ್ಗೆ ನಿಮ್ಮಷ್ಟು ಲೇಬರ್ ಲಾ ಗೊತ್ತಿಲ್ಲ, ಆದ್ರೆ ಸ್ವಲ್ಪ ಓದ್ಕೊಂಡಿವಿ ನಾವು.
Then my lord, there is one thing. I'm now grateful to your lordships. After the compulsory retirement order was passed, he filed a statutory appeal which came to be rejected on 22nd May 2006. That's important. ಅದಾದ್ಮೇಲೆ ನಾನು ಡಿಸ್ಪ್ಯೂಟ್ ರೈಸ್ ಮಾಡಿ.
ಡಿಪಾರ್ಟ್ಮೆಂಟಲ್ ಅಪೀಲ್.
ಹೌದು, ಡಿಪಾರ್ಟ್ಮೆಂಟಲ್ ಅಪೀಲ್ came to be rejected. Appellate authority ಮುಂದೆ, member secretary being the appellate authority, I filed an appeal. Appeal came to be rejected as per the order dated 22nd May 2006. Then I raised a dispute.
Once.
ಅವಾಗ ಡಿಲೇ ಪ್ರಶ್ನೆ ಬರೋದಿಲ್ಲ ಅಂತ.
Did you take up the contention before the appellate authority. That
I have not taken.
he is competent to levy the
I have not
penalty.
taken, I have not taken that penalty. I have not taken that penalty. And I want to be very, very. Adon, one more date may be relevant. What happened, my lord, after the reference was made? Then, my lord, when this compulsory retirement Aadhaar, my date of retirement, my lord, date of, in the normal course, my date of retirement may also be relevant.
Superannuation date. 58 years, another.
How? ಅವಾಗ 58 ಇತ್ತು. 31/1/2018 ರಿಟೈರ್ ಆಗ್ತಾ ಇದ್ದೇನೆ. I sought for some time. ಏನಕ್ಕೆ? What is the benefit he got ಅಂತ ಅನ್ನೋದಕ್ಕೆ.
ಅದನ್ನ ಏನೋ ಒಂದು ಮಾಡೋಣ.
ಅಲ್ಲ, ಅಲ್ಲಿ ಬಂದ್ಬಿಡ್ತೇನೆ. ಒಂದ್ ನಿಮಿಷ ಅದನ್ನು ಹೇಳ್ಬಿಡ್ತೇನೆ.
ಅಲ್ಲ, superannuation date
ಅದಾಯ್ತಾ? ಆಮೇಲೆ ಸ್ವಾಮಿ ಇನ್ನೊಂದು. Since the compulsory retirement being a major penalty, according to the employer for a proved misconduct, that entire period ಏನು ಕೊಡ್ಲಿಲ್ಲ. So right from the date I was placed, of course, suspension period ಒಳಗೆ I got the correct information. He was paid 75% salary.
ನಂಗೆ ನೀವೇನ್ 25%
31st January 2018 in the normal course I would have retired from service because of the compulsory retirement. But the entire period was not given any benefit with regard to continuity. Therefore, my lord, pay no pay fixation based on pension, 13,000 rupees compulsory pension ಬರ್ತಾ ಇರೋದು. 30 facts. Undisputed facts.
13,000
per month.
ಈಗ ಬರ್ತಾ ಇರೋದು. ಲಾಸ್ಟ್ ಪೆನ್ಷನ್ ಪೇ ಇದು ಇದೆಯೇನ? ಇಲ್ಲ.
I am a bit sick.
ಅದು ನಿಮ್ಮ ಕ್ಲೈಂಟ್ ಕರೆಕ್ಟ್ ಹೇಳಿಲ್ಲ.
Correct.
It cannot, because in the meanwhile, 2 commissions have come. 2 pay committee ಆಗಿರೋ ಅದಕ್ಕೆ. ಅವ ನಿಮ್ಮ ಮುಂದೆ ಪುರ ಹೇಳಲ್ಲ. CIT ಅವರು ಏನೋ ಬ್ಯಾಕ್ ವೇಜಸ್ ಎಷ್ಟು ಕೊಟ್ಟರು?
80%. 80%. ಇಷ್ಟೇ ಹೇಳಿದ್ದ ಲಾಸ್ಟ್ ಇಯರ್ ತಾವು ಓದಿ ಅಂದ್ರೆ.
CGIT ಆರ್ಡರ್ ಹೇಳಿ.
CGIT award is dated 24th June 2020. Immediately after publication, the parties have filed the writ petition.
80% back wages.
How? Exactly.
Okay.
These are the facts.
Back wages 80% to full continuity of service ಬಗ್ಗೆ.
ಅದೇ ಓದ್ಬಿಡ್ತೀನಿ ಸ್ವಾಮಿ.
ಅದು ಇದ್ದಿದ್ದಕ್ಕೇನೆ ಪೆನ್ಷನ್ ಕೊಟ್ಟಾರ, ಇಲ್ಲಪ್ಪ ಅಂತ ಕೊಟ್ಟ.
ಹೌದು. ಅಲ್ಲ, without any break up to the date of his superannuation.
Correct.
Superannuation. Any breakup up to the date of his superannuation and pay 80% of the back wages.
superannuation ಅಂದ್ರೆ ಆರ್ಡರ್ ಆಫ್ ಪೆನಲ್ಟಿ ಇತ್ತಲ್ಲ ಅದೇ. ಈ superannuation ಫುಲ್ ಪೆನ್ಷನ್ ಬರ್ತದೆ.
31/1/2018.
It cannot be like that. Word used is wrong. Of English word. Superannuation. Anyway, it's solid. But that's how we have understood. Your client has understood. Government also has understood.
ಈಗ ಆ ಪೀರಿಯಡ್ ಮಾತ್ರ that suspension period, everything ಏನು ಆ period is not. Let us forget about that monetary benefit. What should happen to that period? ಅಲ್ಲೂ ಹೋಗ್ಬಿಡುತ್ತಲ್ಲ ನಮ್ಗೆ ಅಂತ.
ಅದೇನ್ ಬರ್ತೀನಿ held guilty.
ಅಲ್ಲ ಈಗ unless that period is treated for the purpose of pensionary benefit, at least.
Anyway, given up that contention. You have given up that contention before the tribunal. Otherwise, you should have said, inquiry held is not proper.
But I have challenged it. That is my case before the tribunal. Tribunal did not answer that. Tribunal only went on the putting that there is a incompetency on the part of the authority who passed the order.
ನಿಮ್ಮ ಇದು ಎಲ್ಲಿದೆ?
ನನ್ನ claim statement.
ನಿಮ್ಮ ಕ್ಲೇಸ್ ಪೇಟೆಂಟ್ ನಲ್ಲಿ ವೇರ್ ಡಿಡ್ ಯು ಗೆಟ್ ಎನ್ಕ್ವೈರಿ ವಾಸ್ ನಾಟ್ ಪ್ರಾಪರ್ಲಿ ಹೆಲ್ಡ್?
ನಾನು ಹೇಳಿದ್ದೇನೆ. May I request your lordship to kindly-
ಪ್ಲಸ್ ಯು ಶುಡ್ ಹ್ಯಾವ್ ಗಾಟ್ ಇಶ್ಯೂ ಫ್ರೇಮ್ಡ್.
Issue frame ಆಗಿದೆ.
ಆಗಿದೆಯಾ?
7th page annexure page 20 my lord of my lead petition.
ಇಶ್ಯೂ ಫ್ರೇಮ್ it held against you
That
allowing the parties to lead evidence ಅಂತ ಹೋಲ್ಡ್ ಮಾಡಿದ್ರು. That is consistent with Excel where
right from file store ಹೇಳಿದ್ರು.
ಅದ್ರಲ್ಲಿ-
ಅವೇ ಬೇಕಾಗ್ತಲ್ಲ ಹೇಳಿದ್ರಿ. ಅದು ಆಮೇಲೆ ನಮ್ಮ
ಅವರು ಇಬ್ರು ಯು ಆರ್ ಆಸಿಲೇಟಿಂಗ್ ಬಿಟ್ವೀನ್ ಟೂ ಎಕ್ಸ್ಟ್ರೀಮ್ಸ್ ಲೈಕ್ ದ ಪೆಂಡುಲಮ್ ಆಫ್ ದಿ ಕ್ಲಾಕ್.
ಅದಕ್ಕೆ ಮಧ್ಯ ತಾವು
Of course,
Golden-
don't have-
ಅದಕ್ಕೆ ತಾನು ಗೋಲ್ಡನ್ ಮೀನ್ ಅಂತ ಹೇಳಿದೆ. ಅದಕ್ಕೆ ಜೈಪುರ್ ವಿದ್ಯುತ್ ನಿಗಮ ಅದಕ್ಕೆ ಗೋಲ್ಡನ್ ಮೀನ್ ಅಂತ ಹೇಳಿದೆ.
ಎಲ್ಲರಿಗೂ ಕಷ್ಟ ಆಗ್ತದೆ. ಜೀವನ ಕಷ್ಟ ಇದೆ, ಏನ್ ಮಾಡಕ್ ಬರ್ತದೆ? ಲೈಫ್ ಯಾರಿಗೆ ಸ್ಮೂತ್ ಇದೆ? ಆಲ್ವೇಸ್ ಲೈಫ್ ಈಸ್ ಟ್ರಬಲ್ ಸಮ್ ಓನ್ಲಿ. ಹಂಗಾಗಿ PB ಶೆಲ್ಲಿ ಹೇಳಿದ್ದು ಐ ಫಾಲ್ ಆನ್ ದ ಥಾರ್ನ್ಸ್ ಆಫ್ ಲೈಫ್ ಅಂಡ್ ಐ ಬ್ಲೀಡ್ ಅಂತ. ವಿ ಗೋ ಅಂಡ್ ಫಾಲ್ ಆನ್ ದ ಥಾರ್ನ್ಸ್ ಆಫ್ ಲೈಫ್. WP 2027 ನಿಮ್ದು ಕಂಪ್ಯಾನಿಯನ್ WP ಯಾವ್ದದು ಕೊಡಿ, ಅದು ಗೌರ್ಮೆಂಟ್ ಬಂದಿರ್ಬೇಕಲ್ಲ.
3925 ಸೆಟಸಿಟ್ ಬೋರ್ಡ್ ನಂದು 7144 ಫಸ್ಟ್ ಅದು ಎರಡನೇ ತಗೊಂಡ್ಬಿಟ್ರೆ ಒಳ್ಳೇದು. ಅದಕ್ಕೆ ಫ್ಯಾಕ್ಸ್ ಹೇಳಿದ್ ನಾನು. 7144 by the workman.
7144 ಅಲ್ಲ?
By the workman.
7144 ಕೊಡಿ. What ups?
ಅದರೊಳಗೆ ನಾನು ಡೇಟ್ಸ್ ಎಲ್ಲ ಹೇಳಿದೆ. 3925 ಅವರು ಚಾಲೆಂಜಿಂಗ್ ದಿ ಎಂಟೈರ್ ಅವಾರ್ಡ್.
2027 ಅಲ್ಲಿ ಕೊಟ್ಟನಲ್ಲ ಆಗಲೇ ನಾನು ವಾಪಸ್ ನೋಡಿ.
ಇನ್ನೊಬ್ಬ 3925 ಅವ್ರಿಗೆ ಬಟ್ 714 ನೊಳಗೆ ನಾನು ಡೇಟ್ಸ್ ಪರ್ಫೆಕ್ಟ್ ಆಗಿ ಹೇಳಿದ್ದೀನಿ. ಅದು ದಟ್ ಮೇ ಬಿ ಹ್ಯಾಂಡಿ ಅಷ್ಟೇ.
ಬಟ್ ಇಟ್ಸ್ ಎ ಪ್ಲೆಜರ್ ಟು ಹಿಯರ್ ಯು ಆನ್ ಲೇಬರ್ ಮ್ಯಾಟರ್ಸ್.
ಇಲ್ಲ, ನನಗೆ ಅದಕ್ಕೆ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡ್ತೀವಿ ಸ್ವಾಮಿ, ಅದನ್ನ ತಾವು ದಯವಿಟ್ಟು ಗಮನಿಸ್ಬಿಡ್ತಾರೆ.
ಕೊಡಿ.
ಇಲ್ಲೇ ಕೊಡ್ತೀವಿ.
ಮೂರಿದಾವ
ಕೋರ್ಟ್ ಆಫ್
ಗುಜರಾತ್
ಗುಜರಾತ್ ಸ್ಟೀಲ್ ಟು
ರೈಟ್ ಪ್ರಪೋಸಿಷನ್ ಇಟ್
ಅದ್ರೊಳಗೆ
ಹಾ.
ಟ್ಯಾಕ್ಸ್ ಎಲ್ಲ ಇದ್ದ ಮೇಲೆ
ಹಾ.
ತಾವೇ ಮೋಲ್ಡ್ ಮಾಡ್ಬೋದು ಅದನ್ನ
Correct.
ಮತ್ತೆ. ಅದು ಗೊತ್ತಿದೆ, ಆದ್ರೂ ನಾನು ಇದು
oldest judgments
ಅಲ್ಲ,
of
ಈ
Justice
judgment
ಗಜೇಂದ್ರ
ಅದ್ರ-
ಗಡ್ಕರ್.
ಅದೇ ಈ ಜಡ್ಜ್ಮೆಂಟ್ ಓದ್ಬೇಕಾದ್ರೆ ಭಾರಿ ಖುಷಿ ಆಗುತ್ತೆ. ಅಲ್ಲಿ ಎಷ್ಟು ಜನಕ್ಕೆ ಎನ್ಮಾಸ್ ಟರ್ಮಿನೇಷನ್ ಆಗುತ್ತೆ ಗುಜರಾತ್ ಸ್ಟೀಲ್ ನಲ್ಲಿ. ದೆನ್ ಮೇಲೆ ಎಂಟೈರ್ ಸ್ಟ್ರೈಕ್ ಬಗ್ಗೆ ಹೋಗ್ಬಿಟ್ಟು ದೆನ್ ಪ್ಯಾರಾಗ್ರಾಫ್ 145 1 minute.
Krishna Iyer's judgment.
Yes, sir, you must have it. Yes. ಪ್ಯಾರಾ 145 ಅದಷ್ಟು ಮಾತ್ರ ಓದ್ತೀನಿ.
145.
ಹೌದು. We may now crystallize our conclusions
Conclusions in the light of.
in the light of the long discussion. The basic assumption we make is that the strike was not only the latter part. A contrary view cannot be ruled out in the circumstances present. But we do not re-investigate the issue since the High Court
This
has
is under section 11A, we have plenary power, last line.
ತಮ್ಗಿದೆ.
Understood. Got it.
ಬಟ್ ಬಹಳ ಚಂದವಾಗಿದೆ ಜಡ್ಜ್ಮೆಂಟ್.
Hey, it's classic judgment of
ಅದೇ.
Professor Vishweshraya, who was my teacher in law school.
ಅದು 853 ಜನ ಟರ್ಮಿನೇಟ್ ಮಾಡ್ತಾರೆ ಸ್ಟ್ರೈಕ್ ಅಂತ
ಗುಜರಾತ್.
ಗುಜರಾತ್.
ಗುಜರಾತ್. One of the
ಫ್ಯಾಕ್ಟ್ಸ್ ಎಲ್ಲ
judge. Books ಸಹಿತ ಆಗಿದೆ. ಅವ್ರ ಬುಕ್ಸ್ ಎಲ್ಲ ಆಫ್ ದ ಬೆಂಚು, ಡೆತ್ ಎಂಡ್ ಆಫ್ಟರ್ ಎಷ್ಟು ಚಂದ. ಅಂಡ್ ಈ ಜಡ್ಜ್ಮೆಂಟ್ ಇನ್ Bank of Cochin versus Jolly George versus Bank of Cochin. Where Daridra concept was brought in. Rajappa. Definition of very industry andre. That itself is a classic.
Hitting below the belt is not industrial juice.
Is a judgment, another judgment where he said, if you are not capable of paying the living wages, better vanish away. That was the reason.
And they minimum wage ಅಂದ್ರೆ fair wage ಅಂತ ಹೇಳ್ತಾರೆ. ಆ ಕೇಸ್ ನಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ.
Raptacos ಅಲ್ಲ ಅನ್ನೋದು.
Correct.
Yes, thank you. Good luck. Both workman are knocking at of writ court, being aggrieved by the award dated Kutkondi heli. 24 Nayak, our court is not a primary school.
24 June 2020.
We are all participatory workers hostile. 24/6/2020, whereby the punishment of compulsory retirement dated 11/10/2005 having been upheld, correct? The award came to be made for the payment of 80% of back wages. First off, it was in a peculiar circumstance that the competent authority to hand the punishment was not, was executive director.
Member secretary.
Not
the director.
Member secretary
Of the Central Silk Board.
of the Central Silk Board, and not the one who authored it. First, workman's writ petition is WP, workman's challenge is WP number 7144 of 2022, whereas that by the management is 2021. First, foundational facts of the case. Adana Roman 2, para 2 ಮಾಡಬೇಕು heading. ಅದರ ಕೆಳಗಡೆ Roman small I ನಿಂದ begin ಆಗಬೇಕು. ಇದೇ ವರ್ಕ್ ಬಂದ, ಅದು ಬೇರೆ ಅಲ್ಲ ಇನ್ನೊಂದು, ಅದು ಬೇರೆ, ಅದು ಬೇರೆ ಇಲ್ಲ, ಅದು
ಥಿಂಕ್ ಮಾಡೋದೇ ಬೇಡ. ಆಮೇಲೆ ಬೇರೆ
gained entry to service on 30/11/1983 as reeler cum spinner. Semicolon. He earned the promotion as lower division clerk with effect from 26/11/1991. First off, he came to be kept under suspension by order dated 15/11/1995, and happily he was paid the admissible subsistence allowance during this period. First stop. Next paragraph. Charge memo came to be issued against the petition, against the workman on 10th February 2002, 10 to 2006.
June.
Huh?
10th June.
10/6/2000.
10/6.
10/6/2002. 2002. First stop. Inquiry officer and inquiry proceedings were accomplished, culminating into inquiry report dated 4/4/2005, comma, holding the charges proved. First stop. ಇದು ಎರಡನೇ ಪ್ಯಾರಾ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? ಫಸ್ಟ್ ಪ್ಯಾರಾ, ಸೆಕೆಂಡ್ ಪ್ಯಾರಾ. The second show cause notice came to be issued to the workman on 23/6/2005, and he filed his representation to the inquiry report, presumably in the light of Apex Court decision in Ramzan Khan versus so and so, AR 1991, Supreme Court, so and so. First. The disciplinary authority accepted the report and eventually an order of compulsory retirement dated, handed. ಯಾರಿಂದ? ಯಾರದು ಡಿಸಿಪ್ಲಿನರಿ ಅಥಾರಿಟಿ? ಯಾರು?
ಡಿಸಿಪ್ಲಿನರಿ ಅಥಾರಿಟಿ ಇಸ್ ದ ಮೆಂಬರ್ ಸೆಕ್ರೆಟರಿ. ಅಲ್ಲಿ ಅವ್ರು ಮಾಡಿದ್ದು ಮೆಂಬರ್ ಡೈರೆಕ್ಟರ್.
First, this was by the director. First, workman's departmental appeal came to be negatived on 10/5/2006, affirming the order of punishment. First, Mr. Naik, in all fairness, admits that the ground as to competence of the disciplinary authority to levy the punishment was not taken up. First, next paragraph. At the instance of the workman, the central government referred the matter to the CGIT wide CR 77/2008. First, the preliminary issue as to the regularity of the inquiry came to be answered in favor of the management, whole accomplished. First, however, in the light of a learned single judge's order dated 5/1/2007 in WP number 4657/9 of 2003 between R. Narayanaswamy versus the Central Silk Board, comma, the order of punishment came to be interfered in as much as in the said WP it was held that the competent authority to hand punishment of the kind to the class of employee of the kind was the executive member secretary and not the director. Full stop. The CGIT awarded 80% back wages. First, neither the workman is happy nor the management, with the same. First, that is how these two petitions are placed at our hands for disposal this day. First, next paragraph. Learned counsel, Mr. V.S. Naik, appearing for the workman in his inimitative style, argues that once the order of punishment is set at naught, the clock turns back to the fullest effect, and therefore full service ought to have been directed to be counted, and full back wages along with full terminal benefits like pension, gratuity, etc. ought to have been service apex court decision in Gujarat Steel Tubes Limited versus Gujarat Steel Tubes Mazdoor Sabha, AIR 1980, Supreme Court 1896. First, learned counsel appearing for the management is not before us. First, however, that will not come in the way of these old petitions being disposed of on merits. First, next paragraph. Having heard the learned counsel for the learned advocate for the workman, and having perused the petition papers, we are marginally inclined to interfere as under and for the following reasons. First, ಕೆಳಗಡೆ ಇದನ್ನು ಮೇನ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಮಾಡ್ಕೋಬೇಕು. ರೋಮನ್ ಅದು ಕಂಟೆನ್ಷನ್ ಮೇನ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಮಾಡಬೇಕು ನಾಯಕರದು, ಇದನ್ನು ಸಹಿತ ಮತ್ತೊಂದು ಮೇನ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಮಾಡಬೇಕು. ಅದರ ಕೆಳಗಡೆ ಸ್ಮಾಲ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ABCD ಮಾಡಬೇಕು. The fact matrix of the case as to workman gaining entry to the service, earning promotion, being placed in suspension, payment of subsistence allowance, and thereafter suffering issuance of charge memo that eventually resulted into a disciplinary inquiry, culminating into order of compulsory retirement or demonstrated from the records. First, Mr. Nayak, in his usual fairness, does not dispute all this. First, his contention that once the order of penalty is held to be incompetent, there should be a direct reinstatement of the employee wiping out all elements of blemish, comma, appears to be too far-fetched an argument. Full stop. Reasons for this are not far to seek, colon. Firstly, he was placed under suspension and he was paid the admissible subsistence allowance, semicolon. Secondly, the disciplinary inquiry proceedings were accomplished at the hands of retired district judge, and the workman did not raise his little finger as to competence of initiation of the DE. First stop. Even in his departmental appeal filed against the punishment order, comma, he did not take up the contention that the director who handed the order of punishment was incompetent. Full stop. Had it been taken up at the earliest point of time, comma, the appeal that was pending before the executive member secretary would have been remanded for consideration afresh, saving years of life. Full stop. However, in the reference made to the CGIT, comma, Mr. Nayak submits, and we have no reason to doubt that this contention was taken up and urged. Full stop. This next paragraph, be that as it, next paragraph. The contention as to competence of the director to initiate disciplinary inquiry and award the punishment is a bit kind of afterthought. First, such a contention is taken up only because of a learned single judge's decision, which held in another case that the member secretary is competent and not the director. Full stop. Had that contention been taken up ab inceptio, comma, it would have been an order passed without jurisdiction ordinarily is a nullity, semicolon. However, for practical implications, both Indian courts and the English courts have taken a bit different view, as is reflected in AIR 1992 SC 111 paragraphs 5, 6 and 7. First stop. The House of Lords has taken the view that an order may be nullity for one purpose and effective for other purpose, and that there cannot be a thumb rule like thing. First of this, the apex court said after referring to the writings of Professor H.W.R. Wade and Zolovich in their magnum opus, administrative law. First, next paragraph. The claim of Mr. Nayak that once the order of punishment is held to be incompetent, comma, the reinstatement has to follow is not the correct position of law. First up, in the absence of section 11 capital A of the ID Act 1947, comma, perhaps there was scope for invocation, for advancing argument of the kind. First off, a special and peculiar power is vested in the labor court and CGIT to mold the relief depending upon the requirement of reason and justice. First off, the tribunal molded the relief is true, semicolon, but the molding should not be unfair to the management as well, semicolon. Fairness, comma, John Rawls writes, is a pleads fairness has to exhibit fairness to the other side. First off, viewed from a practical point of view, comma, we are of the considered opinion that awarding 80% of back wages when the employee was out of employment is too much, to say the least. First off, at the same time, the workman should be sent empty-handed sounds another extreme. First off, a golden balance has to be struck, not necessarily in between the exactly in the middle of these two extremes, but somewhere keeping in view all the facts and circumstances of the case. First off, we are of the considered view that award of 25% of back wages in the circumstances of the case would meet ends of justice. First off, next paragraph. In the above circumstances, these petitions are disposed of, modifying CGIT award to the effect that the workman shall be paid back wages quantified at the rate of 25% within a period of 3 months if already not paid, and if delay is broken, that amount would become 30% for the first 6 months, 35% for the period next following. First off, this differential may be recovered from the erring officials of the Silk Board. Of course, after the same is remitted to the workman. First off, next paragraph. It hardly needs to be mentioned that the period between 30/11/1983, that is date of entry into service, and 11/10/2005, that is the date of compulsory retirement, which spans a period be considered while as the qualifying service for all terminal benefits for all terminal benefits such as pension, DCRG, etc., as are admissible in law.
Pay fixation.
Pay fixation of pay as well. First, costs made easy. Okay. Registry to send a copy of this judgment to the silk board by speed post.
ಇನ್ನೊಂದನ್ನ ಡೀಲಿಂಗ್ ಮಾಡ್ಬೇಕಂದ್ರೆ ಅದು ಸ್ವಲ್ಪ
ಆಯ್ತು.
ಫ್ಯಾಕ್ಟ್ಸ್ ಡಿಫ್ರೆಂಟ್ ಆಗಿದೆ.
ಹೇಳ್ಬಿಡಿ. ಮುಗಿಸೇ ಬಿಡೋಣ ಅದನ್ನ.
ಅದ್ರೊಳಗೆ
ಹಾ.
ಅದನ್ನ ಫೈಲ್ ಯಾಕೋ ನಾನು ಮಿಸ್ ಆಗಿದೆ ನೋಡ್ಬೇಕು.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೋಣ.
ಹಾಕೋಬಾರ್ದು.
ವೀಕ್ ಆಫ್ಟರ್ ನೆಕ್ಸ್ಟ್ ಕೊಡ್ರಿ ಇನ್ನೊಂದು.
ಆಯ್ತು. ಅದೊಂದು ಮಾತ್ರ ಡೀಲಿಂಗ್ ಅದ್ರೊಳಗೆ ಏನೇನಿದೆ ಸ್ವಲ್ಪ facts.
ಬೇರೆ ಮಾಡಿ.
That it's only case of option from duty.
Okay.
That's it. ಈ ಎರಡು ಡಿಸ್ಪೋಸ್ ಆಯ್ತು 2020.
Okay.
ಅದ್ರಲ್ಲಿ ನಾನು ಒಬ್ಬನೇ ಹಾಕಿರೋದು. I lost before the time.
All. Thank you. Thank you so much. Okay. Very.
My apologies.
Ah.
Challenging the recommendation passed by Lordship's Justice Keshav Narayana Committee, my lords, where of land measuring about 16 guntas has been recommended to be reportedly belongs to respondent numbers 5 to 10.
Others come afternoon. This will take time. Yes.
Respondent numbers 5 to 10, my lords.
May I make one request not before?
Ah.
What has happened with the adjacent lands? Whether this particular portion of a 16 gunta is a matter of subject matter of a dispute before your lordships now.
Correct.
Which was granted, which was allotted in favor of the petitioner by the BDA, not which now not the respondent has been successful before the committee. Lord, what has happened to the next
Respond ಯಾರು? ಏನು?
landowner?
Successful means?
My lords, what happened in KP Anjanappa's case, my lords, is that my lords were pleased to direct all of us to file our representations to the committee to see that whether it is in compliance with Bondu Ramaswamy or not.
Yes.
Now, my lords, I had made a representation. That representation was considered by the committee. BDA filed its objections. BDA said, no, the land should not be denotified. My lords, my lands are not forming part of any layout, etc. But in any event, my lords, today, subject to correction by my learned friend, what has happened insofar as my learned friend's land is concerned is that his land had been acquired by BDA. He was supposed to get another land. 4 sale deeds have been executed, and all 4 sale deeds were a result of litigation, as a result of which now the 5th time my land along with surrounding lands have been given. That the BMRCL is seeking to acquire even the substantial portions of my land as well as other lands belonging to the petitioner. So therefore, my lords, if the petitioner is looking at alternative land, if the because petitioner wants to start an industry, this particular land may not suit that petitioner's purpose. That is my understanding, subject to what my friend would say. Because subsequent to filing of
I have made the disclosure, my lords. The BMRCL acquisition has already happened way back in the year 2020, page 218 of my writ petition.
ಈಗಾಗಲೇ ಆಗಿ ಹೋಗಿದೆ.
ಅದು only 3 guntas was acquired.
ಇಲ್ಲ.
Now, my lords, they are acquiring the entire extent. That is what, my lords, my client has informed me, my lords, I asked, because Tahsildar has apparently approached and made a notification. My lords, we'll place those documents, my lords.
BMRCL and party matter. Will direct the BMRCL to make a party. Berkeley.
Lords, because
is directed to array BMRCL as a respondent number
11, my lord.
11. Since it is said that the subject land is being notified for acquisition. No. First stop. Yaro counsel?
Krishna.
Shri panel counsel?
K. Krishna.
Mr. K. Krishna is requested to accept notice for BMRCL. First, petitioner to serve a copy of the petition along with all the documents on the panel council immediately.
In this
Call
matter,
this matter next week.
fix a date, my lord. I'll.
ಅವ್ರಿಗೆ copy ಕೊಡಕ್ಕಲ್ಲ ಮತ್ತೆ ನೀವು.
ಅಲ್ಲ,
Then
ನೀವು
ಕೊಡ್ತೀನಿ,
ತಾವು
ಕೊಡ್ತೀನಿ.
ಯಾವತ್ತಾರು one date fix I'll get those original records, my lord, for your lordship's consideration also.
Oh.
That is why I'm requesting for a date.
March. In three.
And please, my lords. Monday.
Amend ಮಾಡಿಕೊಡಿ.
Maybe extend.
Meeting moderator continue.
There are some additional memo. I'll file some documents are there. I'll file it along.
ಅವ್ರಿಗೆ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿಕೊಡಿ.
Everything before 10:30.
ಯಾರನ್ನು ಸರ್ಪ್ರೈಸ್ ಇಂದ ತಗೋಬಾರ್ದು.
Aste. That is,
ಹೌದು.
I'll serve before.
ಅವ್ರಿಗೆ so that they come with preparation. Charity, how is your health now? You're all right?
Yes, my back is improved.
Improved.
Yes. Obliged.
Appearing for the petitioner, Lords, this is a matter which is arising out of the impugned judgment. The committee,
Tell him friend,
which we tried to look for him.
here,
Not here.
not here.
Not
Any
here.
entry
The
ಮಾಡಿದ್ರೆ
difficulty here is it's a matter pertaining to 11 quintas of land that has been deleted between the petitioner's land. 100/5, which is subject matter of the Honorable Justice Keshwanan Committee, has been deleted recently, Lords. I would like to place that by way of records. Portion in the, except for one portion, it's been upheld as acquisition. Now, while the matter is pending, they took possession of the property. Now, when the matter is pending, it appears that they've allotted the said 3 sites in between my 2 properties to someone.
already allotment is made.
Please. And that number is contrary to what they have disclosed in the Keshwanan Committee. Please, I'll just hand over this.
ಅಲ್ಲಿ ನೋಡ್ಕೊಳ್ಳಿ. sorry.
PDA, I'll just serve a copy of it.
ಅವ್ರು ಮತ್ತೆ ಪಾರ್ಟಿ ಮಾಡ್ಬೇಕಿತ್ತು.
Party ಇದಾರೆ.
ಈಗಾಗಲೇ ಇದಾರ.
Party there. Mr. Girish, Lords, we tried to.
Party
I will
might-
make a party because I just got to know.
Learned
But at least the maintain status quo.
Petitioner is directed to array allottees of the sites in question as a
Page 85, Lords.
response ಹೇಳಿ.
Respondents number
Respondent numbers
528, 5678.
5678,
Please, Lords.
5678.
85, Lords. Page 85.
First, learned counsel appearing for the petitioner with leave of the court has amended the cause title. First, issue emergent notice to the newly added parties, returnable within 10 days.
Please.
First, the party shall maintain status quo in respect of subject line till next date of hearing.
Give.
Okay. ಇದನ್ನ ಮಾಡ್ಕೊಡಿ, ಅದು ಅಮೆಂಡ್ ಮಾಡ್ಕೊಡಿ.
That is also an amendment.
ಅದು amendment ಈಗ.
Please, because this land is subject is between 2 of the petitioners. That may be allowed.
The application seeking leave of the court to amend the pleadings is supported by an affidavit. First, this amendment is proposed in the light of certain latest developments that took place at the hands of the BDA because of the recommendation of Honorable Justice Keshav Narayana Committee. First, denying leave would cause injustice to the petitioners. First, grant would do justice to both the sides. Above circumstances, application having been favored for, comma, within 1 week.
Please, sir.
Within 1 week. I- First, call this matter after 3 weeks.
Grateful.
Or forever.
But that
Committee
may be
error.
dispensed, Lords, because committee.
Notice to Justice Keshavarana committee is dispensed.
Dispensed. Should we file a memo?
Member on the oral submission of the petitioner.
Great.
Okay. Petitioner's counsel. Okay. ನೋಡೋಣ ಸ್ಟ್ರಕ್ಚರ್ ಕರೆಕ್ಟ್ ಆಗಿ ಯಾವ ರೀತಿ ಮಾಡ್ಕೋಬೇಕು. ಓಕೆ. His father was a great lawyer. He passed away. Yes.
I'm appearing for the appellant, Your Lordship.
ಏನಿದೆ? Arrest.
Can
Head.
appeal number 34, Your Lordship, that is for 2015-16.
Serial number 34. Serial number 34.
ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 12, 14.
For the earlier year.
34 is earlier.
Earlier year. 32 is the later year.
12 of 22. STA 12.
Your Lordship. Your Lordship, the appellant, Your Lordship, is a works contractor.
Works contract.
It's a works contractor. Your Lordship. And yet he files his returns, and the returns were presumed to be self-assessed under the Karnataka value addition. If there is any
35 what?
38 1.
38, 1.
38.
38. 1.
Yes. Your Lord. Accepting my self-assessment, he would issue a notice under 39-1 for reassessment. Lordship, the reassessment notice, Your Lordship.
ಅವ್ರು ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ರು ನಿಮಗೆ.
They issued the reassessment notice, Your Lordship. That is at Annexure D, Your Lordship. There were various grounds.
And questions of law ಏನಿದೆ?
Your Lordship, SMR, it was taken up for revision. The order passed by the.
Questions of law ಏನಿದೆ?
Your Lordship, it's only pertaining to the labor charges which has been deducted,
Read,
Your
read.
Lordship.
Read. Where have you framed?
Your Lordship, it's at
Where have you framed the
58, Your
questions?
Lordship.
Huh?
Page 58, Your Lordship. I've reframed the question of law because there was a mistake, so.
Lordship may see the order dated 18/7/23.
Lordship,
18/23 order.
page 60, Your Lordship, whether the fact and
Powers of division under 64 set aside the reassessment in the absence of satisfying. Pin conditions adumbrated by the.
Your Lordship, the first question of law is on whether the revision SMR was to be invoked under section 64 of the Act or not. I will come to that, Your Lordship. And the next question is already Supreme Court, Your Lordship. It's in terms of deduction of labor charges, which was allowed to me by the adjudicating authority by way of a revision, by way looking at the document. This was supposed to be revised by SMR by issuing a notice under section 64. This I would the SMR all the deduction. Lordship, it is labor and life charges which has been deducted. My Lord, the Supreme Court has stated in the case of works contract, what has to be charged to tax is only the cost of material which gets incorporated in the works plus the gross profit.
Correct.
That is the decision of the Supreme Court, and Gannon Duncan.
That is
Gannon Dunkerley.
Yes, Your Lordship. That is
Yes.
second Gannon-Dunkley, which says that the abatement can be provided from the total turnover to the extent of labor and like charges and other service expenses. This abatement, this deduction was claimed by me in my return. And the adjudicating authority, during the course of reassessment, Your Lordship, the reassessment notice was issued in Annexure D, and the order of reassessment.
Bani, after 1:30, we are framing some judgments. Therefore, next week ಹಾಕೋಣ ನಾನು. Next week ಹಾಕೋಬೋದಾ? Because you have other matter na?
39.
ಅಷ್ಟೇ ಕೇಸ್ ತಾನೆ?
Yes.
That's the works component cannot be subject matter of taxation. And Dunkerley. 6629 capital
is relevant for this.
26629B.
69A.
That is reflected in.
Yes, Your Lordship. After the amendment, every state's made an amendment to give deduction to the labor and like charges.
Because that article itself said.
Yes, Your Lordship.
All states should make accordingly amendment at the night.
Yes.
Which Aditya argued already. Anyway, we'll have it. Week after. Judgments.
2:30 minutes, Your Lordship.
Enter. Eleven.
The 30 to 34, next week, next week or the week next. Next week, I think next week next also. Week next.
In any circumstances, the CCH5 matter is going to be called up. All adjourned to next week. Okay, can I get a date for any of the matter? Again. It won't be called out, no, so I can leave, no?
Yes, sir. ಸರ್ ಯಾವ್ದು ಕರೀತೀರಾ ಸರ್ ಯಾವ್ದು ಕರೀತೀರಾ ಒಂದಲ್ಲ ಫಸ್ಟಿಗೆ ಕರೀತೀರಾ
Yes. Okay. 35, 37, ಇದು ಮುಗಿಸೋತಿ ಅದಾದ್ಮೇಲೆ ನೋಡೋಣ. Next week of next week.
ಯಾವ್ದು? ಇಲ್ಲ 35, 37 ವೆಂಕಟೇಶ್. That may be detached now. There the question is something else.
Separate. Yes. Note.
Also have one small mention. Subject what Mullen did not arise at all from the order of the tribunal. Point for consideration, should it be detagged or should it be dismissed?
It appears it has been mechanically done. Unfortunately.
Having heard the ಹೇಳಿ ಬರ್ಕೊಳ್ಳಿ. Having heard learned AGA for the revenue and learned senior advocate appearing for the assessee. Some time to withdraw petition so that a fresh petition in an appropriate form and substance can be filed in accordance with law. First, in that connection, ordered accordingly, and the petition is disposed of as having been withdrawn, cost being made easy. Easy. First, all. 39.3 ತಾನೆ?
39.3.
Okay. ಅಲ್ಲಿ ಅವರಿಗೆ ನೋಟಿಸ್ ತಗೊಂಬಿಡಿ. ಅಲ್ಲೊಂದು while computing period of limitation for filing up.
And it is whether further intelligence.
I had taken your lordship's permission. So I had entered the scene at that point in time, filed a better affidavit, then your lordship said, so I.
Last event, it hardly needs to be mentioned that while computing the period of limitation for filing the petition in contemplation, comma, 63 would be invocable. Okay, this much you have. Otherwise injustice ಆಗ್ತದೆ. Okay.
Lots on limitation.
Nothing.
I don't think either side would press on it very hard. So it's.
So long as senior is appearing, it is not a problem. Otherwise, your lordship have seen some cases, limitation itself has become a.
ದೊಡ್ಡ ಇಶ್ಯೂ ಆಗಿ ಹೋಗಿದೆ. ಅದು ಯಾಕೆ ಅಷ್ಟು ಮಾಡ್ತಾರೆ ಅಂತ ಅಫ್ಕೋರ್ಸ್ ಹಂಗೆ ಅನ್ಕೊಂಡು ಲಿಮಿಟೇಷನ್ ಅನ್ನ ತೀರಾ.
In fact, my lord, of late, the Honorable Supreme Court has been consistently dismissing the condemnation petitions beyond 300 days. Unless and until a
Very
really
special
solid case is
circumstance.
made out, not because of anything else, only to make sure that the revenue would come well prepared and come in proper.
ಇದು ನಮ್ದೆಲ್ಲ ಅಷ್ಟ್ರಲ್ಲಿ ಬರ್ಲಿದ್ರೆ ಇಲ್ಲೇ ಇಲ್ಲ.
Law is made
Clear.
crystal clear.
People will know where they stand.
Exactly.
ಒಂದ್ ಸ್ವಲ್ಪ ದಿವ್ಸ ಕಷ್ಟ ಆಗ್ತದೆ, ಅವರು ವಿಕ್ಟಿಮ್ಸ್ ಅವ್ರು, ನಾವೇನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಎಸ್.
Ships may kindly take STRP 33 of 2023. It's serial number 39, the first in the sequence.
But these what
P 46 of 2022, if he's agreeable, if he's comfortable.
Allah, mostly he has read these papers and come back. Huh?
The reason, my lord, see, this is the earliest of the order and the other order completely subject to his convenience.
46, one,
STRP 46.
my lords. I have in that page 25, ink page 25, paragraph 5, my lords. First appellate.
Input tax rate on the ground that selling dealers have not declared and paid output taxes and levying interest and penalty thereon. Put
The
so to clear payment tax is a precondition ಅನ್ನೋ ಅರ್ಥದಲ್ಲಿ ಅಲ್ಲ. ಏನು ಅರ್ಥ ಕ್ವಶನ್?
Question is, do you have considered this as a precondition?
ನೋಡೋಣ. How
My lords to
very good.
as your lordships have seen in numerous matters, a purchasing dealer buys inputs for his activity from selling dealers. There is a tax component that is paid to the selling dealer. So supposing I buy paper to publish a book, there may be VAT. The tax that is already paid on the paper, I while when my eventual tax liability will the entire chain be complete. If I've got benefit of 12 rupees, that 12 rupees also has to reach the coffers of the state. Now there are two possibilities. One is, three possibilities. One is that a selling dealer promptly pays the tax, files his return, everything is done.
Which you have paid.
Yes, which I have paid. The selling dealer promptly pays his tax, first files the return, computes the tax correctly within the prescribed period. It is paid also. And then when I claim the input tax credit, the department is able to tally that, look, 12 rupees is collected through this And therefore now his credit of 12 rupees and that output tax of 12 rupees is now the tally. Maybe his chartered accountant is unwell, maybe he's going through a business loss, something, there is some delay, some discrepancy.
He collects tax but does not remit.
Does collects tax, does not remit, maybe his returns are slightly delayed within the permissible time limit, etc. He does that.
One is transaction.
Transaction.
Where he collects tax.
Yes.
Number two is where he collects but pays with the delay.
Or
three is he does not pay.
Any bona fide reason, there may any otherwise a well-established dealer is carrying out business. There may be some discrepancy, some accounting issue, some cash crunch. Something has happened which has prevented him for a quarter or otherwise. Circumstance arise, my lords, where the dealer is sometimes fictitious or the dealer is temporarily registered, then as soon as these transactions get over,
Cancels the registration.
cancels the registration and thereafter it is not. Or the dealer is dealing with all kinds of cash transactions. He has no record of what is being sold. He has no record of what tax he has collected, what he has to or there is under declaration in the returns. There is no ability to tally. At that point,
the fact that you have paid tax,
maybe so.
is there.
Maybe so. Maybe so. At that point in time, my lord, does not reach the coffers of the state and the state takes it up for reassessment. And I ask, look, these are dealers who have either subsequently deregistered themselves or have not paid, or look, their declarations are showing nil returns. They have not, they have not undergone any transactions. No tax has reached the coffers of the state. Please show me that you are entitled to claim this input tax credit. In other words, I cast a doubt on his eligibility to claim input tax credit.
1 second. My duty to pay tax is discharged once I make payment.
Yes.
What he will do with that, what control I will have over him?
Absolutely none. Absolutely none.
Unless you make law.
Absolutely.
Saying that like under Hindu law.
Yes.
Where Karta is selling the property for family necessity.
Yes.
Kutumbarte, Vyavaharike, Idavalla more.
Yes.
Apatkale. Avaga, the buyer of the property has to make reasonable inquiry whether what is projected is true or not, then he should enter into transaction.
Correct.
Once Chaitanya remits the tax which is prescribed in law,
yes,
what control he can have over the suicide of the seller? Seller commits suicide. What is it? Where is the law on that?
That law on an interpretation of section 70 initially by back industries of our court and then Ecom Gilbert. No, the Supreme Court goes further. It says it is his duty to establish the transaction, the movement or receipts.
It's all evidential.
etc. It is all evidence of the transaction because I have introduced a doubt in the system by showing that these are dealers who appear to be fly by night. They have not remitted tax. They have filed nil return, etc. Now the question is whether by merely showing a bank statement or a photocopy of a demand draft or does the buyer need to go further in the discharge of the burden of proof once I have created this doubt? The second is, here is the registration certificate that was given to me at the time that I entered into this contract with me. Here is a copy of the check. Here is my bank statement. And in some mysterious circumstances, he seems to have his bank statement also. He says, I'm not connected. But in some cases, his bank statement also comes. Be that as it may. Supreme Court, my lord, says, no, you have to show the actual movement and delivery of goods. To produce any other circumstance where the burden shifts from the person who affirmed happened under section 70 till the buyer discharges it, there is no movement on the onus of goods, on the onus of proof. Third thing Supreme Court says is that the standard which I am now attributing is beyond doubt, which my lord, I have submitted beyond doubt is an expression above beyond reasonable doubt also. But I would temper it to say, I have introduced a doubt by creating a by questioning the bona fide of the sellers. You overcome that doubt. Beyond doubt means the doubt that I have raised.
But question which page 20 is structure that appears to be wrong.
Appears to be wrong. Appears to be wrong and
obligates the buyer of the goods to control what the seller is going to do. In other words, if the buyer demonstrates whether he remits it or not, you should have made appropriate. You should have said you remit it to directly Deputy Commissioner instead of that person, etc. That's not your case.
No, no. Lords, my kindly see, my lords.
Do you doubt he has paid the tax? Who is claiming it?
Lords, supposing I make some cash purchases from some other state, able to import something. Some inputs are brought in. Say some car parts in Dubai, easily available. I load it on a ship in Dubai Harbor. And I unload it somewhere close to Mangalore and I bring it in. On smuggled parts from Dubai. I have to account for it. So, I look for some person, maybe, somebody who works in my office and say, listen, why don't you become a dealer of car parts? Right? And I will send you some money. You have given me these goods. And after So in order to prevent that from happening, the burden under 70 is cast. And now the Supreme Court says how that has to be discharged. My question of law will also be somewhat mechanical. My lord, it's in page 13. Second question, may I? First and second question both. According to me, the second is primary. First is only in the nature of doubt.
If I may add, first question is from the lowest of the department, that is never the question. That is never the aspect.
It's not raised at all. There
The
is no such
learned
thing.
assessing
No
officer-
fact matrix for raising that.
Not at all, because that is never the case. If my learned friend may point out, but that has never been the case. The first question wouldn't even arise.
Whether the tribunal was right in allowing the respondent's appeal and setting aside the disallowance of input tax credit claimed by the respondent, despite the fact that the respondent had question number 2 will arise.
My lords, in question 1,
Question one may not, but 2 will arise.
2 would arise.
2 will arise.
2 would arise subject to the facts of the case.
Correct.
Yes, yes.
By Chaitanya is not demonstrated.
Payment of tax. To say satisfied.
What remains?
That is the short question. Is that the only?
You should police the person who has unfortunate. How can you proceed against him? ನೀ ಪೇಮೆಂಟ್ ಮಾಡಿಲ್ಲ ಹಂಗಾಗಿ ಮಾಡ ಪೇಮೆಂಟ್ ಅಂತ ಹೇಳೋದು ಬೇರೆ. ನೀನು ಅವನಿಗೆ ಪೇಮೆಂಟ್ ಮಾಡಿದ್ದು ಪ್ರೂವ್ ಆಗಿದೆ. ಸ್ಟಿಲ್ ವಿ ವಾಂಟ್ ಟು ಹೋಲ್ಡ್ ಯು ಲಯಬಲ್ ಬಿಕಾಸ್ ನೀ ಮಾಡಿದ ಪೇಮೆಂಟ್ ಅನ್ನ ಅವ ಗವರ್ಮೆಂಟ್ ರೆಮಿಟ್ ಮಾಡಿಲ್ಲ ಅನ್ನೋದು ಯಾವ ಸೆಕ್ಷನ್ ಕೊಡುತ್ತೆ? Proof of payment is one thing. Once that proof that I have made the payment, what control he will have over the seller? He all transactional their relationship. Nanu goods be car bekitta kodave what?
Now, in that case, he needs further than merely the bank transaction.
Correct.
To show the delivery.
I'm in full agreement with you.
In this case, he does not accept.
So far as you can demand the proof you can demand to prove you have made the
Yes.
That duty, once that duty is
beyond that, the movement of goods, delivery of goods has not been proven. In the absence of that, the burden under 70 is not closed.
where how that doubt has arrived, officer.
Page 67.
67.
Payment ಡೆಮಾನ್ಸ್ಟ್ರೇಟ್ ಮಾಡಿಲ್ಲ ಅನ್ಕೊಂಡು ಎಲ್ಲಿ ಡಿಸ್ಕಷನ್ ಆಗಿದೆ ಯಾವ ಪೇಪರ್ಸ್ ನಲ್ಲಿ? ಕಂಪ್ಲೀಟ್ಲಿ ರಾಂಗ್ ಕ್ವಶನ್. ಅದು it may on the face of the record. But if otherwise, the end product of the order is sustainable. Tax. ಅದಕ್ಕೆ ಇನ್ಪುಟ್ ಟ್ಯಾಕ್ಸ್ ಕ್ರೆಡಿಟ್ ಅಂತೀರಾ ನೀವು? ಇನ್ಪುಟ್ ಟ್ಯಾಕ್ಸ್ ಕ್ರೆಡಿಟ್. ಅದಕ್ಕೆ ಎಲ್ಲಿದೆ ಪ್ರೂಫ್ ಅಂತ ಕೇಳಿರಿ ನೀವು. ಆ ಕ್ವಶನ್ ಹೆಂಗಿರ್ತದೆ ಎಲ್ಲಿ ಟ್ರೀಟ್ ಮಾಡಿದ್ದಾರೆ? Take the first step.
Page 60. Eight two.
The contention.
And then your lordships may kindly come to page 61. It is that any claim to deduction of input tax is correct, including the onus of proving the tax is so paid, the seller are in turn paid to the government. The background of this, the purchase is entitled to on the website of the Department of Commercial Tax, such as e-returns, e-payments, e-registration.
Taxes collected.
Yes.
So input
Collected.
he has not remitted it
He has
to the
not.
government.
He has not.
That is the case.
Yes, yes. Electronic cross verification of input tax credit was also carried out by matching the sales and purchase details of both the assessee and the seller, and it is found that dealers mentioned have passed on input tax credit without actually paying it to the government, along with the returns, which the assessee company has claimed the assumption that it is correct.
This appears to be wrong. They have made a payment.
No, the selling dealers have not made the payment.
Selling point adalla.
Correct.
The buyer payment
Buyer has made the payment.
in duty ಇದೆ. ನಿಮ್ಮ ಪ್ರಕಾರನ he
Page 30.
your doubt relax credit. He has claimed ಅಲ್ಲ. He has made
Yes, yes,
the credit.
yes.
ಎಲ್ಲಿದೆ ಅದ್ರ ಬಗ್ಗೆ ಎಲ್ಲಿ?
He has claimed input tax credit without.
No, he is claim ಅಲ್ಲ. He has made the payment of tax. Output tax
Yes, ma'am.
If he has paid the tax
To a private person
to a private person only,
who has not,
who sells the goods.
absolutely. Who has not remitted inward.
What is he, my control over
There
it?
is no control. There is no control.
ಏನಿಲ್ಲ. ಇದನ್ನ ಹೆಂಗ್ ಮಾಡ್ತೀರಿ ಅಂತ ಹೌ ಇದ್ರಲ್ಲಿ ಏನ್ ನಂಗೆ ತಿಳಿತಾನೆ ಇಲ್ಲ ಹೆಂಗೆ ಇದು ಅವ್ರನ್ನ ನೀವು ಹೌ ಯು ಕ್ಯಾನ್ ಟ್ರಬಲ್ ಹಿಮ್ ಅನ್ನೋದು ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ ನನಗೆ.
He is required, in my respectful submission, my lord, to go only 2 steps further and show the movement of the goods and the receipt of the goods. If he meets the test in E-com Gill, which in this record, in the tribunal's order, is nowhere to be found, your lordships, I bowed out. Because then it fits within the category of a genuine transaction, and he has discharges burden of proof. He has absolutely, which is why I started with, there may be.
ನಿಮ್ಗೆ ಅನ್ಸ್ಬಿಟ್ರೆ ಡೌಟ್ ಇಂಟ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. ಅದು ಗೀತೆಯಲ್ಲಿ ಶ್ಲೋಕ ಇದೆ, ಸಂಶಯಾತ್ಮ ಪ್ರಣಶ್ಯತಿ ಅಂತ. ಆ ಸಂಶಯ ಅಲ್ಲ. ಇವನ್ ಬೈಬಲ್ ಸೇಸ್ ಡೌಟಿಂಗ್ ಥಾಮಸ್ ಗೋಸ್ ಟು ದ ಹೆಲ್ ಅಂತ. ಯುವರ್ ಆಫೀಸರ್ ಶುಡ್ ನಾಟ್ ಬಿ ಎ ಡೌಟಿಂಗ್ ಥಾಮಸ್. ಜೆನ್ಯುಯಿನ್ ಡೌಟ್ ಇರಬೇಕು.
Lordships may kindly take. One of the appellant at the time of hearing, the appellant there was the respondent here. In support of its claim of input tax for the transaction effected with the aforesaid selling dealers, 37 in number, for the tax period in question, has produced selling dealer wise 37 photocopies of purchase invoices, extract of purchase register, and extract of purchase ledger, extract of bank statement to show for the first time be that as it may.
Both on law and facts.
Both on law and facts.
ಹಂಗೆ ಹೋಲ್ಡ್ ಮಾಡಿದಾರ?
ಹೌದು. My lords, otherwise there is no trial court here.
There is one judgment ಇದೆ. First appeal otherwise says ಅಂತ ಒಂದು ಪ್ರಿಸಂಪ್ಷನ್ ಇದೆ. ಇದು ಸೆಕೆಂಡ್ ಅಪೀಲ್ ಇದ್ದಂಗಿದೆ. But it treated an appeal only.
Appeal also is an appellate
63 treats.
The reason, my lord, says this is essentially a tribunalization of the court. Before it would come to high court on a substantial question of law.
ಅಲ್ಲ, ಹೈಕೋರ್ಟಿಗೆ ಸಬ್ಸ್ಟಾನ್ಷಿಯಲ್ ಇಲ್ಲ, ಅದಕ್ಕೆ ಬರೀ ಕ್ವಶನ್ ಆಫ್ ಲಾ ಇದೆ. In variance like your law.
Your lordship may see 5.
ಓದಿ.
Shall, after giving both parties
ಸ್ಕೋಪ್ ಆಫ್ ಅಪೀಲ್ ಅನ್ನು ಡಿಸೈಡ್ ಮಾಡಿದಂತ ಫೌಂಡೇಶನಲ್ ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಇಲ್ವಾ?
ಇರ್ಬೇಕು.
Lords, there are surely, but in section 254, subsection 5, says the finding of fact is final.
Therefore it will arrive at ಅಂತದೆಲ್ಲಿದೆ ಇಲ್ಲಿ ಅಂತ.
Finality ಇದ್ರಲ್ಲಿಲ್ಲ, ಆದ್ರೆ when my lords would consider it, the appeal lies only on a question of law.
Facts should be held to have jurisdiction
until, if I'm not, which is not the instant case. And my lords, there are a few decisions on my lords, of course, on substantial question from my lords, it predicates.
ಏನ್ ಡಿಫರೆನ್ಸ್ ಎರಡು?
Give where my lords in
Also remember that judgment.
Yes, yes, yes. A substantial question of law should give pure question of law. And what a question of law, my lords, would be, of course, interpreters. The Supreme Court Justice Dattu, my lords, has said that, my lord, what would give rise to a substantial question of law? About 6 tests are given in Santosh Hajari versus Tiwari. One, my lord, says led by the apex court or the jurisdictional high court. Something that would substantially affect
have elements of virginity.
Elements of
it should relate to the case.
Not only that, my lords, it may relate to the case, it may be too trivial an issue.
How I understood. Someone deals with that. Any question, someone decides 4 types of questions. He says all questions that arise before the court and tribunals are only 4. One is question of fact, another is question of law, third is question of discretion, fourth is question of opinion. There is no other question on that. A question of fact means which has to be answered by looking to the evidentiary record, whether Alexander came to India in BC 323. Question of whether Alexander like man will come December is a question of opinion. Opinions have to be. Amounts to murder is a question of law, because you have to turn section 300, 302, then you will answer 299, 300 of IPC, then you answer that. This is question of discretion is whether 3 years to 7 years imprisonment. Just ಕೊಡಬೇಕಪ್ಪ ಇದರಲ್ಲಿ. It's a question of discretion ಅನ್ಕೊಂಡು his view ಇದೆ ಆ ರೀತಿ. ನಾನು ಕ್ವಶನ್ ಆಫ್ ಲಾನು ಟ್ರೀಟ್ ಮಾಡಿದೆ ಆದಿತ್ಯ ಒಂದೆರಡು ಮ್ಯಾಟರ್ಸ್ ನಲ್ಲಿ ಆದಿತ್ಯ ವೆರಿ Following that Bora Muslim matter one from Sir Marthena, while I was sitting in Harvard bench under income tax. What I thought, because almost like 100 of CPC. All importance of the CPC ಅಲ್ಲಿ 76 amendment ಆದ್ಮೇಲೆ substantial question of law ಅಂತ ಮಾಡಿಬಿಟ್ರು. ಅದು in other words, a question should arise from the facts of the case and the answer to that question should have a bearing on the outcome of the proceeding ಅಂತ ಹೋಲ್ಡ್ ಮಾಡಿದೆ. ಆ ಕ್ವಶನ್ ರೇಸ್ ಮಾಡಿ ಅದು ಆನ್ಸರ್ ಹೀಗೆ ಇರಲಿ ಹಾಗೇ ಇರಲಿ, ಕಾನ್ಸಿಕ್ವೆನ್ಸ್ ಸೇಮ್ ಇತ್ತು ಅಂದ್ರೆ irrelevant ಆಗಿಬಿಡುತ್ತದೆ, ನಮ್ಗೆ ಅಕಾಡೆಮಿಕ್ ಆಗಿಬಿಡುತ್ತದೆ ಪ್ಯೂರ್.
Milords, what the lords have just now said is said except in a slightly different language. In Santosh Hazari, what they've said is the question
proceedings.
Exactly.
In other words,
Exactly.
rights and duties of the obligations of the parties ಮೇಲೆ bearing ಇರಬೇಕು.
That would then promote to become a substantial question. This is the, this Milords is the.
ಅಂತದೆ substantial ಅನ್ನೋದು ಯೂಸ್ ಮಾಡಿಲ್ಲ ಅನ್ನೋದು ಬಿಟ್ರೆ, otherwise it's no difference between substantial question of law and question of law.
Milords, in a given case, both will convert. In a given case, some come in appeal. Particularly when the revenue would come in appeal or the assessor would come in appeal before a forum like the Honorable High Court, they would not be keen on pursuing some academic matter.
To moon or not.
Exactly.
Comes to court for that purpose.
So this Milord, what Milords in Dharwad held, which is nothing but an echo of what Milord Santosh Hazari said, except that the wording could be little different. Much later, or maybe sometime around the same time, the Honorable Supreme Court in Vijay Kumar Talwar's case, 330 ITR page 1, Milord, has gone on to reiterate the precedent case law on what is substantial question of law, and reiterated all that and finally concluded saying, I've carried the copy of it also, Milords. Like in the,
it should have a bearing.
Exactly. It should have a bearing.
ಅದು ರಫ್ ಮನುಷ್ಯನ ಭಾಷೆಯಲ್ಲಿ ಹೇಳ್ಬೇಕು ಅಂದ್ರೆ, ಆ ಪಾರ್ಟಿ ರೈಟ್ಸ್ ಏನಾಗ್ತದೆ, ಇದಕ್ಕೆ ಉತ್ತರ ಹಿಂಗ್ ಕೊಟ್ರೆ ಏನಾಗ್ತದೆ, ಹಿಂಗ್ ಕೊಟ್ರೆ ಏನಾಗ್ತದೆ. ಆ ದೃಷ್ಟಿಯಿಂದ ಅಷ್ಟೇ. Yeah, he had argued that matter already.
And I was hoping, Milords, to see if, because the VAT Act refers to the Karnataka Appellate Tribunal Act. Karnataka Appellate Tribunal, when it says powers of the tribunal goes back to the Karnataka, but unfortunately it is not there. So I took the train back to the Sales Tax Act, but was not able to find anything.
One logic, what Chaitanya said.
Yes, that
question of law means rest of the things you have completed at the lower level. Otherwise,
better cast under 63, that the appeal can only be on questions of law or substantial question of law or otherwise.
Milords, may kindly see subsection 1 for a while.
Of
Section 63. That will give the scope in which Milords would be considering in terms of section 65. If these two provisions are juxtaposed, that would make it clear that even a question
appeal to the appellate tribunal.
Exactly. Milords, subsection 1. Any officer by the state
may appeal to the appellate to an order passed by the appellate authority under section 60.
Yes,
appellate
now,
may
now
admit an appeal
section 2.
referred up to the 60
May
days
admit an appeal.
in a further period of 100. No, the limitation valid.
And subsection 3.
The absurd person against 2 laziness, the 30 but you may not But so file appeal.
This may be now compared with my lord.
Hello, the cross objections.
Hello,
In appeal, in
subsection
CPC.
one, subsection one, which my lord just now have read. Which will
From facts and law.
not on what. Whereas if my lords were to compare, come to section 65.
It is on question of.
Exactly.
law.
Within 180 days,
The
on the ground that the appellate tribunal has either failed to decide or decided erroneously any question of law. This,
That-
my lords, will make it clear. that
Otherwise, they would have said here it.
They would have said that. Is how, my lords?
So this is a ulterior ಅಂತ ಏನೋ ಬರುತ್ತಲ್ಲ. ಒಂದು ಮ್ಯಾಕ್ಸಿಮ್ ಬರುತ್ತಲ್ಲ.
Ulterior.
ಇದು ಎಕ್ಸ್ಕ್ಲೂಸಿವ್ ಈ ಕಡೆ ಆಗ್ತದೆ.
Lords, the bench of the Honorable Supreme Court in GT has elaborated this.
Where it's a
Question of one thing is exclusive. Further
this one, and they cautioned all. A good servant, but bad masters, Mr. How law ಇವೆಲ್ಲ ಸರಿಯಾಗಿ ತಿಳಿಸಿರಲಿಲ್ಲ ನಮಗೆ.
Just before my lords would proceed with my learned friend on facts of the case, one subsection 12 may also be seen. Section 63, subsection 12, which is important.
Every order,
Every
what
order-
the appellate tribunal under section 9.65 be final.
That means except on a question of law.
ಇಲ್ಲ ಹಂಗಾಗಲ್ಲ. ಇದನ್ನ ಇಂಟರ್ಪ್ರಿಟ್ ಮಾಡಿದ. ಬಿ ಫೈನಲ್ ಅಂದ್ರೆ ಏನು ಅನ್ಕೊಂಡು ಗುರುರಾಜ ಅವರ ಯಾಕೆಂದ್ರೆ ಅಲ್ಲಿ ಅಪೀಲ್ ಅನ್ ಕ್ವಶನ್ ಆಫ್ ಲಾ ಮೇಲೆ ಇಟ್ಟಾರೆ. ಅದಕ್ಕೆ ನೀವು ಅಪೀಲ್ ಈಸ್ ಆನ್ ಫೈನಲ್ ಅಂದ್ರೆ ಏನು ಅನ್ನೋ ಪ್ರಶ್ನೆನೇ ಡಿಸ್ಕಸ್ ಆಗಿದೆ. ಚೆನ್ನಾಗಿದೆ ಆ ಜಡ್ಜ್ಮೆಂಟ್, ಯಾವಾಗಾರ ಒಂದ್ ಸರಿ ನೋಡಿ. ಮೇ ನಾಟ್ ಫೀಲ್ ಲೈಕ್ ಎಸ್. 93 or 94 ಕರ್ನಾಟಕ. ಅದನ್ನ ತೆಗಿರಿ. ಗುರುರಾಜ್ ಏಲಿಯಾಸ್ ಗುರುರಾಜ್ ಕುಲಕರ್ಣಿ ವರ್ಸಸ್ ಲ್ಯಾಂಡ್ ಟ್ರೈಬ್ಯುನಲ್ ಫುಲ್ ಬೆಂಚ್ ಡಿಸಿಷನ್ of our High Court. Yes.
Your Lordships, before I go to the impugned order.
Yes.
Your Lordships, may kindly see the first appellate authority's order.
At page.
Your Lordships, may come directly to about 46. It starts at 41.
Yes.
Bottom of 46.
In response to.
Yes. In response to call notice, Shri so-and-so learned advocate and DAR for the appellant appeared before this authority and reiterated the grounds of appeal. The only issue at dispute in this appeal with regard to disallowance of input tax credit. The respondent is perfectly justified in rejecting the claim of input tax credit to the extent the selling dealers have not deposited the tax to the department by filing the dealers for the reason that the principle of strict construction would
Any subsequent sale to. ಏನ್ ಹಂಗಂದ್ರೆ?
the tax on the subsequent sale is only.
It goes to next. ನಿಮ್ದು ಬಂದು ಇದು ಅಲ್ಲಿ ತನಕ ಹೋಗೋದೇ ಅಲ್ಲ ಇದು.
But the minus barala, then he goes.
Okay.
It constitutes a chain and any break would result in chaos. These findings are recorded in the judgment rendered by Division Bench of Kerala High Court in the case of so-and-so versus State of Kerala, reported in 2013, 63 KLJ, Kerala. In the case of the appellant, the respondent in the course of reassessment proceedings has noticed that the appellant has effected purchases of goods from local registered dealer who have not satisfactorily complied with the payment of tax to the extent input tax credit claimed by the appellant. The appellant has failed to prove bona fides of the above selling dealers and has not established the burden cast on him under 71 of the KVAT Act.
ಏನ್ ಬರ್ಡ್ ಅನ್ನೋದು? Please explain this to us. ಅವನು ಆ ಗೌರ್ಮೆಂಟ್ ಕೊಟ್ಟಾನೆ ಅನ್ಕೊಂಡು ನಾ ಪ್ರೂವ್ ಮಾಡು ಅಂದ್ರೆ ಹೆಂಗೆ? ಅದನ್ನು ಓದ್ಕೊಳ್ಳಿ, ಇನ್ನೊಂದ್ಸರಿ ಓದಿ.
That the appellant, in the case of the
appellant has failed to prove the bona fide of the above selling dealers. Our bona fide deal ನೀವು ಯಾರಿಂದ ಬೈ ಮಾಡಿರಲ್ಲ ಅವ್ರದ್ದು bona fide ನಾ ಪ್ರೂವ್ ಮಾಡ್ಬೇಕು. ಏನನ್ನ? dealers, and has not established the burden cast upon him under section 70 of the act.
Correct.
To prove that the selling dealers have in fact paid the taxes on the purchases made from them. And this established.
He may be overstating the case. He has to stop at the bona fide or the genuineness of the transaction.
Correct.
He has to stop there. This may be overstating the case. I have no control on the selling dealers. That debate is allowable on the basis of documentary evidence to be produced by the dealer claiming the input tax credit, which must establish not only charging of tax in the tax invoice, but it must.
One second, ಇದು ನೋಡಿ. ಇಲ್ಲೇ ಬರೋದು ಪ್ರಾಬ್ಲಮ್. ಕ್ಲಾರಿಟಿನೇ ಇಲ್ಲ ಇವೆಲ್ಲ ರೂಲಿಂಗ್ಸ್ ನಲ್ಲಿ.
Defensible ಇಲ್ಲ ಅದು. It is mandatory on part of the dealer claiming the input tax credit under 10(3) of the KVAT Act to discharge the burden cast upon him by proving that the transaction.
It is mandatory on the part of the dealer claiming input tax credit under section 10(3) of the Act 2003 to discharge the burden cast upon him by proving that the transactions are genuine.
Yes.
And the selling dealers are identifiable and have in fact paid tax.
That last line, Manoj,
ಆಮೇಲೆ ಉಳಿದಿದ್ದೇನು ಅಂದ್ರೆ ಬಾಡಿಯಾಗಿ ಉಳಿಯೋದೇ ಅಲ್ಲ. ಅಂತ ಕೇರಳ ಜಜ್ಮೆಂಟ್ ಏನು ಈ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ನಲ್ಲಿ ಇದು ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಆಗಿದೆಯಾ? ವೆದರ್ ಎ ಹ್ಯಾಸ್ ಸೋಲ್ಡ್ ದ ಗುಡ್ಸ್ ಟು ಬಿ, ವೆದರ್ ಬಿ ಹ್ಯಾಸ್ ಪೇಡ್ ದ ಟ್ಯಾಕ್ಸ್ ಆನ್ ದಿ ಸೋಲ್ಡ್ ಗುಡ್ಸ್. ಮುಗೀತು. ಆ ಟ್ಯಾಕ್ಸ್ ಅನ್ನ ಏನ್ ಮಾಡಿದೆ ಅನ್ನೋದು ನನ್ ಕಂಟ್ರೋಲ್.
I will have to enforce against his assets in any manner known to law.
Otherwise, you should make law that it is the duty of every buyer who takes churmuri from the seller to ensure that remit it to the government at law ಮಾಡಬೇಕು. ಅವಾಗ ಬರ್ತದೆ.
GST ಅಲ್ಲಿ if it is not credited, there is no claim, sir.
It's a policy matter. It's open to the state to make law.
In GST, unless it is credited, there is no claim for input tax.
ಅದಿಂತದಿಲ್ಲ ಅಂತಿಲ್ಲ.
ಅಲ್ಲಿ ಇಲ್ಲ.
That supports the case of the other side.
Provided he discharges his burden
Correct.
on the genuineness of the transaction.
ಅದಕ್ಕೆ ಒಂದು ನಿಮಿಷ, ಅದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂಗೆ ಕೈಂಡ್ಲಿ ಕಮ್ ಟು, ನೀವೇ ಓದಿದ್ದು ಕೈಂಡ್ಲಿ ಕಮ್ ಟು ಪೇಜ್ 31. ಅವನು ಏನೆಲ್ಲ ಮಾಡಿದಾನ ನೋಡಿ, ಪ್ಯಾರಾ 34 ಬನ್ನಿ. ಟ್ರೈಬ್ನಲ್
ಎಸ್
ಆಗ ಕೇಳಿದೆ ನಾನು, ಲಾ ಅಂಡ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಮೇಲೆ ಎರಡರ ಮೇಲೂ ಇದೆ ಟ್ರೈಬ್ನಲ್. ಇಲ್ಲಷ್ಟೇ ಲಾ ಮೇಲೆ ಇದ್ದೇವೆ ನಾವು. ಈ ಫೈಂಡಿಂಗ್ ಹೆಂಗಿದೆ ನೋಡ್ಕೊಳ್ಳಿ. The appellant at the time of hearing.
The appellant at the time of hearing, in support of its claim of input and the transaction effected with the aforesaid selling dealers, 37 in number, for the tax period in question, has produced selling dealer wise 37 in number, photocopies of purchase invoices, extract of purchase register, extract of purchase ledger, extract
of bank statement
to show that the
place through banks. ನಿಮ್ದು ನೀ ಏನ್ ಬ್ಯಾಂಕ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಯಲ್ಲ, that itself is not genuine ಅಂದಿದ್ರೆ, then he would have said, all right, I will call the bank manager, we'll ask them to produce the bankers book ಅಂತ ಆಕ್ಟ್ ಇದೆ ಅಲ್ಲ ಅದರಲ್ಲಿ.
Yes, I'm saying I have not gone there, but I'm saying it is not sufficient. Kindly see what he says next. Para 36. Perusal of the documents coupled with payments made by the appellant to the registered selling dealers. 37 in number.
At page, which page you are reading now?
I'm on page 32, my notes.
The perusal of documents coupled with
payments made by the appellant to the registered selling dealers. 37 in number. Your lordship will mark the next two words. Prima facie establishes the occurrence of a transaction between the appellant and the selling dealers. No doubt, under the scheme of the statute, burden is on the appellant dealer who claims input tax credit to prove the validity of the transaction. However, burden of proof is not static, but shifts once the initial burden is discharged. Here he starts getting into trouble. This is my respectful submission.
37 also should be read.
37, I'll come to 39. In fact, from 37. I'll go ahead. In the present case on hand, the appellant has placed ample materials to establish that a transaction as required under the statute has occurred. From the documents placed on record, it can be deduced that the documents pertain to relevant tax period. Details of payment proves that the payment is made to the particular selling dealer out of the total selling dealers, 37 in number, for the relevant tax period. Hence, the payment made by the appellant for the tax period in question is therefore not in dispute and enforces the fact that the primary and most necessary implication to prove that there has been a transaction between selling dealer and the appellant is met. Hence, this implication satisfies the initial burden cast upon the appellant by the statute. Now he reinforces his mistake. Kindly see, my lords. Next. 39, 38. I'll read 38. I'll read. As already discussed about this, above the selling dealers, 37 in number, with whom the appellant has effected transactions during the period in question, have all got valid TIN number during the relevant tax period. However, even though it is the contention of the authority below that the selling dealers, 37 in number, have declared their sales turnover by either filing a nil return or not filing a return, the payment details furnished by the selling dealers and the same filed by the learned counsel show that the payments have been made by the appellant to the relevant tax period. Luckily, he keeps stopping at payment. Next, kindly see. It goes without saying, then you should not say it. It goes without saying, in view of the settled position of the law, that once the appellant has discharged initial burden by producing the invoices reflecting TIN number of the selling dealer, it is for the authorities below to show the same by placing necessary
documents regarding the authenticity of the transaction and details of deregistration of the dealer, if any, at the relevant point in time. It is pertinent to note that this is a second appeal and respondents have not made any earnest effort to place relevance to the fact of deregistration of the selling dealer during the relevant tax period to substantiate their stand. In the absence of any documentary evidence regarding the deregistration of the above, presumption regarding that registration tilts in favor of the appellant.
Appellant is assessee.
Assessee. Your Lordship may come to 51.
51.
I can read from 49. But 51 is where.
ಅವನು burden of proof and onus of proof ಇದೆ.
ಅರ್ಥ ಮಾಡಿ
ಅವ ಹಂಗೆ ಯಾವ್ದೋ ರತನ್ ಲಾಲ್ ಧಿರಜ್ ಯಾವ್ದೋ ಒಂದು ಪ್ಯಾರಾಗ್ರಾಫ್ ಅನ್ನು 2 ಸೆಂಟೆನ್ಸ್ ತೊಗೊಂಡು ಬರ್ದ್ ಹಾಕ್ಬಿಟ್ಟಾನ.
ಹೌದು,
ಅದೆಲ್ಲ ದೊಡ್ಡ ಕಾನ್ಸೆಪ್ಟ್. ವೆನ್ ಬರ್ಡನ್ ಆಫ್ ಪ್ರೂಫ್ ಡಿಸ್ಚಾರ್ಜ್, ವೆನ್ ಓನಸ್ ಶಿಫ್ಟ್ಸ್, ಎಲ್ಲ ಹೈಯರ್ ಆಸ್ಪೆಕ್ಟ್ಸ್ ಆಫ್ ಲಾ ಆಫ್ ಎವಿಡೆನ್ಸ್. ರೂಪರ್ಟ್ ಕ್ರಾಸ್ ಆನ್ ಎವಿಡೆನ್ಸ್ ಬಹಳ ಬ್ಯೂಟಿಫುಲಿ ಟ್ರೀಟ್ ಮಾಡ್ಯಾರ. ಫೀಲ್ಡ್ ಆನ್ ಎವಿಡೆನ್ಸ್ ಚಂದ ಮಾಡಿದ್ದಾರೆ. ನಂಗೆ 2 ಬುಕ್ ಬಹಳ ಲೈಕು. ಇನ್ನೊಂದು ನಾನು ಅದ್ರ ಮೇಲೆ ಓದಿದ್ದು ಅಂತಂದ್ರೆ The Woodruff and Amir Ali.
Woodruff, your lordships are aware, had other credentials also.
Yes. He was a sage. He became monk.
He's a tantric practitioner.
Tantra he studied.
Yes.
Then, yes, yeah, he studied the tantra and he became a tantrika afterwards. He said, my cremation should take place, treating me as a Brahmin anta helbarda hagtana avanu. Avun cremation hangagtadu. Or that fellow. Anyway, not much concern. ಯಾರಿಗೂ ಓದೋದು ಬೇಡ. ಕ್ಷೀಣಿಸಿ ಹೋಗಿದೆ. ಆಮೇಲೆ ಆ ಶಕ್ತಿ ಇಲ್ಲ. ಓದಿದ್ರು ತಿಳಿಬೇಕಲ್ಲ, ಅದ್ರ ಗ್ರಾಸ್ಪು ಮರ್ಮಗಳು ಪೂರ ಅರ್ಥ ಆಗ್ಲಿಕ್ಕೆ ಅದಕ್ಕೆಲ್ಲ ಬಹಳ ಕಷ್ಟಪಡ್ಬೇಕಾಗ್ತದೆ. ಸಾಧನೆ ಬೇಕಾಗ್ತದೆ. ಹಂಗೆ ಏನೋ 2 ಪುಸ್ತಕ ಓದಿಂದ ಯಾವ್ದೋ ಒಂದು PhD ಥೀಸಿಸ್ ಬರ್ದಂಗೆ ಬರ್ದು ಮುಗಿಸ್ಬಿಟ್ರೆ ಅದನ್ನ. Yes.
51, my lords, he comes to some conclusion. Admittedly, in the case on hand, selling dealers 37 in numbers were registered dealers having valid TIN number. An appellant has produced the invoices, books of accounts, along with payment details. In light of the above discussions, transactions are genuine and bona fide in the absence of collusion or otherwise. Hence, in the present case of the appellant, it can be seen that the appellant has not contravened to the extent set aside. Then thereafter he says,
in proposition idu,
what is required for him to meet the burden of proof?
ಆ ಪ್ರಶ್ನೆ ಹೋಗುದಿಲ್ಲ ಅಂತ. Therefore I say, law of ನಲ್ಲಿ ಇವನು ಆ ರತನ್ ಲಾಲ್ ಧಿರನ್ ಲಾಲ್ 2-3 ಪ್ಯಾರಾಗ್ರಾಫ್ ಓದಿಕೊಂಡು ಅವ್ನು ಪ್ರಿಂಟ್ ಮಾಡ್ಯಾನ ಅನ್ನೋದು ಬಿಟ್ರೆ ಆರ್ಡರ್ನಲ್ಲಿ ಅವ ನಿಮ್ಮ ಕನ್ಸರ್ನ್ ಆಫೀಸರ್. ಆ ರೀತಿ ಡಿಸ್ಚಾರ್ಜ್ ಅಂದ್ರೆ ಇದಿಷ್ಟು ಮುಗಿತು ಮುಂದೆ ಇವ್ರದ್ದು ಸ್ಟಾರ್ಟ್ ಹಂಗಿಲ್ಲ. ಅದು
ಹಂಗಲ್ಲ,
ಅಲ್ಲಿ ತನಕ ಹೋಗುದೇ ಇಲ್ಲ ಅದು.
ಹೌದು,
ಒಂದು ಸಾರಿ ನೀವು ಪ್ರೊಬೆಬಲೈಸ್ ಮಾಡಿಬಿಟ್ರಿ ಅಂದ್ರೆ ಕೇಸನ್ನ, ಅದು ರಿಬಟಲ್ಲಿಗೆ ಆ ರೀತಿ ರಿಬಟಲ್ಲಿಗೆ ಹೋಗಲ್ಲ. ಅದು ರಿಬಟಲ್ಲಿಗೆ ಸ್ಕೋಪ್ ಬೇಕು. ಸರಿಯಾಗಿ ನಂಗೆ ಆರ್ಟಿಕ್ಯುಲೇಟ್ ಮಾಡಿ ಹೇಳಲಿಕ್ಕೆ ಯಾವಾಗೂ ನನಗೆ ಈ ಶಿಫ್ಟಿಂಗ್ ಆಫ್ ಬರ್ಡನ್, ಶಿಫ್ಟಿಂಗ್ ಆಫ್ ಓನಸ್ ಬಂದಾಗ ಎಷ್ಟು ಸಾರಿ ನನಗೆ ಒಂದ್ ರೀತಿ ಅದು ಕ್ರಿಮಿನಲ್ ಲಾದಲ್ಲಿ, ಬಿಕಾಸ್ ಐ ಸ್ಯಾಟ್ ಆನ್ ದ ಕ್ರಿಮಿನಲ್ಸ್, ನಂಗೆ ಆ ಕ್ವಶನ್ ಹಂಗೆ ಉಳಿದು ಬಿಡ್ತಿತ್ತು. ಯಾವಾಗ ಇದು ರಿಬಟಲ್ಲಿಗೆ ಹೋಗ್ತದೆ ಅಂತ. ಕೇಸ್ ಫಾರ್ ರಿಬಟಲ್ ಬೇಕಾಗ್ತದೆ, ಅದನ್ನ ನೀವು ಹೇಳ್ಬೇಕು. ಇದು ಕೇಸ್ ಫಾರ್ ರಿಬಟಲ್ ಇದೆ, ಇದು ಹಂಗಾಗಿ ಅಲ್ಲಿಗೆ ಹೋಗತ್ತೆ ಅಂತ. ಯಾವಾಗದು? ಅದಕ್ಕೆ ಸೆಕ್ಷನ್ 114 ಆಫ್ ದಿ ಎವಿಡೆನ್ಸ್ ಆಕ್ಟ್ ಓದ್ಬೇಕು. Court may presume,
presumptions.
Court shall presume conclusive proof. 3 ಕಾನ್ಸೆಪ್ಟ್ ಅನ್ನು ಓದ್ಕೋಬೇಕು. Coupled with 101 to 109 ಆಫ್ ಎವಿಡೆನ್ಸ್. ಅಲ್ಲಿ ಏನಾಗ್ತದೆ? where court may presume 114 ಆಫ್ ದಿ ಎವಿಡೆನ್ಸ್. ಎಷ್ಟು ಚಂದ ಬರ್ದ ನಾವು. which Fitzgerald, where regard being had to common course of event, nature of human beings, and in the totality of the circumstances, court may presume that the illustration, the buyer of stolen goods himself is a thief or has knowingly bought the stolen goods. Illustration ಅಷ್ಟು ಚಂದ ಇದಾವ, ಅವುಗಳನ್ನು ತೆಗಿಲಿಕ್ಕೆ ಸಹಿತ ಆಗಲ್ಲ. ಅದು ಮೇ ಇದ್ದಾಗ ಒಂದ್ಸಾರಿ ಮೇ ಮಾಡಿಕೊಂಡ್ರು, then you will ask him, all right, not for presumption. Ultimately, presumptions, so they operate with burden of proof. This is what Wellman on evidence says. They operate with, because if I raise presumption in your favor, burden is on him to say, no, no, it's not like that. Sir. Court may presume, court may not presume at all. Lot of discretion avails to the court shall presume. Court is bound to presume. It cannot say, I may presume, I may not presume. Court is bound to presume. If for example, section 16 of the Land Acquisition Act, where the notification is issued by the appropriate government, saying that we have taken possession of the land, court shall presume it to, it shall be conclusive proof of what is stated in the notification. Conclusive proof andakshana deeming adu. It does not contra evidence at all. It is conclusive. The conclusion excludes rebuttal. This is basic. There may be conclusive effect of evidence outside conclusive proof. Conclusive proof is a question more of law, because law mandates that, for example, section 112 of the evidence. If a person is 270 days, 270 days of the marriage, it shall be conclusive proof that he is a legitimate child. 112. If access is shown, access opportunity for sexual intercourse is shown, conclusive proof arises. And one case, he was jailed. ಜೈಲಿನಲ್ಲಿದ್ದಾಗ ಅವನ ಹೆಂಡತಿ ಮಗು ಹರಿದು ಬಿಡ್ತಾಳೆ. It is not my child. ಅವಾಗ ಇವ ಕ್ವಶನ್ ಕೇಳ್ತಾನೆ, ಏನೋ ಒಂದ್ಸಲಿ ಹಂಗ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. ನಮ್ಮ employer, he used to teach evidence to us. ಏನ್ ಪ್ರಾಗ್ಮ್ಯಾಟಿಕ್ ಅಂದ್ರೆ ರೀತಿ ಸಿನಿಮಾ ನೋಡ್ದಂಗ ಆಗ್ತಿರ್ತೀವಿ. ಏನು ಆ ಪೆರಿ ಮ್ಯಾಸನು, ಅಗಾಥ ಕ್ರಿಸ್ತಿ, ಇವ್ರು ನಾವೆಲ್ ಸುಧಕಾರ ಆಗತ್ತಲ್ಲ, ಆ ರೀತಿ ಅನಿಸ್ತು. ಹಂಗ ಆ ರೀತಿ ಟೀಚಿಂಗ್ ಅವ್ರವೆಲ್ಲ.
It all depends on how it is taught.
How it is taught.
Evidence
How we learn also. How
that, my lord, the tribunal's order is half-baked and therefore deserves to be set aside. ಇದು ಓದ್ಬಿಡ್ತೀನಿ ನಾನು. E-sugam ಗಿಲ್.
ಅದನ್ನೊಂದು ಕೇಸ್ನಲ್ಲಿ ರೆಫರ್ ಮಾಡಿದ್ರಿ ನೀವು. We have referred to in one of my judgments. We have referred to that Supreme Court decision where it says it is not even beyond reasonable doubt.
Beyond doubt.
It is reasonable doubt.
Beyond doubt.
Beyond doubt, not reasonable doubt.
Not yours.
ನಾವು ಟ್ರೀಟ್ ಮಾಡಿದಂತೆ ಅದೊಂದು ಜಡ್ಜ್ಮೆಂಟ್.
Lordships judgment ಕೊಟ್ರ? If we come directly to page 23.
Just the provision
para
section
23.
70
My.
quoted herein above. Para 23.
Thus, the provisions of section 70 quoted herein above, in its plain terms, clearly stipulate that the burden of proving the ITC claim is correct lies upon the purchasing dealer claiming the ITC. Burden of proof that the ITC claim is correct is squarely upon the SSE, who has to discharge the said burden. Merely because the dealer claiming such ITC claims that he is a bona fide purchaser is not enough and sufficient. The burden of proving the claiming such ITC, such a burden of proof, the revenue, action of invoices or the payment made by checks is not enough and cannot be said to be discharging the burden of dealer claiming ITC has to prove beyond doubt that the actual transaction, payment of freight charges, acknowledgement of taking delivery of goods, tax invoices, and payment particulars, etc. One line later, my lords. In fact, if a dealer claims input tax credit on purchases, such dealer shall have to prove and establish the actual physical movement of goods, genuineness of transactions by furnishing the details referred above, and mere production of tax invoices, so and so, so and so.
Correct. ನಿಮ್ ಡೌಟ್ ಅದರಿಂದ ಎದ್ದೆಲ್ಲ. The doubt which he wanted to introduce, ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಹೇಳ್ಬೇಕಿತ್ತು, ಅದು ಅಲ್ಲೇ ಇಲ್ಲ. ಇವನು ಪೇಮೆಂಟ್ ಮಾಡಿದ್ದೆಲ್ಲ ಸರಿ ಇದೆ, ಅವ ಸೆಲ್ಲರ್ ಅಲ್ಲಿ ರೆಮಿಟ್ ಮಾಡಲಿಲ್ಲ, ಹಂಗಾಗಿ ಡೌಟ್ ಇಲ್ಲಿ ಹೇಳ್ತದೆ ಅಂತ. ಹೌ ಕ್ಯಾನ್ ದಟ್ ಬಿ? That is not the parameters of that is not of para 23 at all.
Once I create the doubt,
which doubt?
Because the selling dealer now has not remitted it, has not reached my coffers.
That cannot be a ground, and that is not spoken of here. Your doubt should arise not because he has not remitted the money, because I have not shown the material that I have paid the tax due on the commodities which have come to my domain.
No,
ಆ ರೀತಿಯಲ್ಲಿ ಡೌಟ್ ಹುಟ್ಟಬೇಕು. ಅವನದನ್ನ ಪೇ ಮಾಡ್ಲಿದ್ರೆ ನಾವೇನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ.
No, where what I would respectfully say, I should have, in conducting my factual inquiry or investigation, gone and gathered some.
No, that's not.
There are no way bills.
That's not your case.
That's not here. That's not here.
ಇಲ್ಲ.
I have only said.
ಕೇಸ್ ಹೆಂಗ್ ಬಿಲ್ಡ್ ಮಾಡ್ಯಾರ ಅಂದ್ರೆ, ಅವ ದುಡ್ಡು ಏನ್ ತಗೊಂಡ, ಅವನ್ ಗವರ್ಮೆಂಟಿಗೆ ರೆಮಿಟ್ ಮಾಡ್ಲಿಲ್ಲ. ಹಂಗಾಗಿ ನಾವು ನಿಮಗೆ ಅದು ಕ್ವಶನ್ ನೋಡಿದ್ರೆ ಗೊತ್ತಾಗ್ತದೆ. ಕ್ವಶನ್ ಅನ್ನು ಹೆಂಗ್ ಫ್ರೇಮ್ ಮಾಡ್ಯಾರ ಅಂದ್ರೆ, ಯು ಕಾಂಟ್ ಕ್ಲೇಮ್ ಇನ್ಪುಟ್ ಟ್ಯಾಕ್ಸ್ ಕ್ರೆಡಿಟ್ ಅನ್ಲೆಸ್ ದ ಪರ್ಸನ್ to whom you have made payment has remitted it to Caesar.
That is not there at all. That is not there at all. That is not there at all. Right. At the stage of fact finding, I should have gone a step further and said, look, in one case it is 37, in another case it is 22. This looks doubtful. Moreover, I have gone to the place of these seller.
And he has also not remitted.
He has not remitted for sure. It is not there in his declaration of return also, my lord. It is not there in his return. When it is not there in his return, the only other argument is that he, in fact, disputes by not including it in a return, he disputes the existence of the transaction. When the return, my lord, under his return, the selling dealer's return, your lordship may see.
ಅಲ್ಲಿ ಹೇಳಿಲ್ಲ ಅವನು, ಅದನ್ನ ಅಡ್ಮಿಟ್ ಮಾಡಿಬಿಟ್ವಿ ನಾವು. He has not declared at all.
He is not declared.
ಅದು ಅವನ ಡಿಕ್ಲರೇಷನ್, ಅವನ ಅಕೌಂಟೆಂಟ್ ನನ್ನ ಮನೆಗೆ ಬಂದ್ಕೊಂಡು ಕೇಳ್ಕೊಂಡು ಅದನ್ನ ಫಿಲ್ಅಪ್ ಮಾಡಲ್ಲ ಅವ. ಬಂದ್ ಕೇಳಿ.
Yes. Your lordship will see para 25. In the present case, evidence and material on record. In some of the
Para
cases,
25 of
the judgment,
judgment.
my apologies.
Correct. The present case, the respective purchasing dealer
Dealers have produced either the invoices or payment of checks to claim ITC. Assessing officer has doubted the genuineness of the transactions by giving cogent reasons on the basis of the evidence and material on record. In some of the cases, the registration of the selling dealers has been cancelled, or even the sale of the concerned dealers has been disputed and or denied by the concerned dealer. My submission, my lord, is that this dispute/denial can occur when the sale transaction does not figure in his returns.
Sale transaction does not figure in the returns of the seller. It may.
It does not.
But if I independently produce the material, that the transaction has happened. I have produced the bank statement also.
The
invoices I have produced. Number of invoices match with the number of transactions. And you do not doubt them. Doubt evidentiary material.
Evidence.
You should doubt the evidentiary material. Avaga, onus may shift. Not otherwise. You do not doubt my bank statement at all. You do not doubt the genuineness of the copies of the statements, invoices, etc. Still you want to doubt. Where? Our doubt is there. Our doubt should arise on some normative basis.
It should have some leg to stand on.
Evidence and doubt ಮಾಡಬೇಕು. ಅಥವಾ ಇದು sufficient ಆಗಲ್ಲ ಅಂತ ಹೇಳ್ಬೇಕು. ಆಗಲ್ಲ ಅಂತ ಹೇಳ್ಬೇಕು. ಹಂಗಿಲ್ಲ.
Once I have a doubt, that doubt, your lordships are seeing that the doubt that I have raised is linear in character. It simply says
legal character. You put it. You have put it very aptly. It partakes the character of a suspicion. Doubt is different. Suspicion is different. There is one famous statement. The sea of suspicion has no shore. The sea of suspicion has no shore at all. ಅದಕ್ಕೆ ದಂಡೆನೇ ಇಲ್ಲ. ಅಲ್ವೇ ದಡ ಇಲ್ಲದ ಸಮುದ್ರ ಸಾಗರ. ಸಸ್ಪಿಷನ್ ಅಲ್ಲ ಇದು. ಡೌಟ್ ಇದು. ಡೌಟ್ ಬೇರೆ, ಸಸ್ಪಿಷನ್ ಬೇರೆ. ಯಾವಾಗ when you suspect the genuineness of the documents, when you doubt the genuineness of the document, between these two, ಅಲ್ಲೆಲ್ಲೋ ಒಂದು ಕಡೆ ಒಂದು linguistic similarity ಕಾಣ್ತದೆ. Yes, but in law, the difference is maintained.
One case where I had succeeded before a lot.
Not criminal case. It is not a criminal case.
It is not a
where you expect, even in criminal jurisprudence, Kenny's outlines of criminal law or Smith and Hogan on criminal cases and materials, ಅವನ್ನೆಲ್ಲ ನೋಡಿದ್ರೆ ಎಷ್ಟು ಸರಿ ಅನಿಸ್ತಿರ್ತದೆ. ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಬರ್ಡನ್ ಜಾಸ್ತಿ. ಅಕ್ಯೂಸ್ಡ್ ತನ್ನ ಡಿಫೆನ್ಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ಪ್ರಿಪಾಂಡರೆನ್ಸ್ ಆಫ್ ಪ್ರೊಬೆಬಿಲಿಟಿ. More often than that, that's another thing. Every dealer is a shady character ಅನ್ನೋ ರೀತಿ ಬಹಳ ಕಡೆ ಹೆಂಗ ಅನಿಸ್ತಿರ್ತದೆ. ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ನಲ್ಲಿ many time have legal character.
Your lordships may then, if your lordships are pleased to set aside the reasoning in the tribunal's order, but say that my appellate authority, first appellate authority, independent of the tribunal's order, does not meet the doubt cast is not sufficient.
Doubt, legal character of the doubt illa.
Legal character of the doubt is.
The doubt may arise because of biochemical reactions that happen in the man's body. Therefore, Lord that samshayatma pranashyati. Because it is doubt which will have legal character, which you said.
Legal character.
Are it the doubt?
So your lordships may consider setting aside the order of the reasoning of the tribunal. And in the case of seniors clients, the 5 petitions, the benefit may be continued.
ಆ ಕ್ವಶನ್ಸ್ ಹೇಳಲ್ಲ ಈಗ ಕ್ವಶನ್ ಹಿಂಗೆ ಫ್ರೇಮ್ ಮಾಡಕ್ಕೆ ಹೋಗ ಇನ್ ಆರ್ಡರ್ ಟು ಕ್ಲೇಮ್ input credit tax, whether the is remitted by his seller to the state.
The question, then, my lords, then that, then I don't.
ಏನಿಲ್ಲ ಏನ್ dismissed. ಅಲ್ಲೇ discuss sea of suspicion has no shore. It should not be a case of doubting Thomas. Semicolon. Too much doubting may be a psychological disorder because of the biochemical reactions. First, that is not enacted in the VAT Act. The provisions of section 63 5. Therefore, functionaries under these provisions have to be very reasonable. First off, the onus of proof, burden of proof, shifting of onus. We'll structure
Those small
judgment of apex. Yeah.
Lord may also add, if it's not inappropriate, what Lord Krishna said.
Samshayatma pranashyati.
It's important that our judgments carry what Bhagavad Gita says also.
So,
and lastly, my lords, and impossibility of performance. Also, maybe a point for
that also. No provision is demonstrated from the Act that tax has a duty to ensure that to the exchequer.
Unlike, my lords, section 16
of, unlike section
16
of
section 16 within brackets 2,
16(2) of
within brackets small c,
bracket C
of the CGST Act. my lords.
CGST. Only proof of remittance is a must. That makes all the difference.
Exactly.
Adon patti copy.
The
Refer to apex.
The finding may be disturbed. Is on shifting of burden of proof, because Apex Court says that that is not possible.
Finding.
He says that the initial burden, subsequent burden, that may be that may be.
ಅದ್ರ ಮೇಲೆ ಅಂತ ಒಳ್ಳೆ ಪುಸ್ತಕ ಸಿಕ್ಕಿಲ್ಲ ನಂಗೆ. ಎಲ್ಲಿ ಯಾವ ರೀತಿ ಶಿಫ್ಟ್ ಆಗ್ತದೆ, ನಾನು ಸ್ವಲ್ಪ ಇಂಗ್ಲಿಷ್ ಲಾ ಆಫ್ ಎವಿಡೆನ್ಸ್ ನೋಡಿದೆ ನಾನು, ಆಮೇಲೆ ಫೀಲ್ಡ್ ಆನ್ ಎವಿಡೆನ್ಸ್ ನೋಡಿದೆ ನಾನು, ಅಲ್ಲಿ ಅಯ್ಯರ್ ಅಂಡ್ ಅಯ್ಯರ್ ಆನ್ ಎವಿಡೆನ್ಸ್ ನೋಡಿದೆ ನಾನು. ನಮ್ಮ ಯಾವ ಎಂಥ ರಾವರು ನಮ್ಮಲ್ಲಿ ಜಡ್ಜ್ ರಿಟೈರ್ಡ್ ಜಡ್ಜ್ ಕೇರಳ ಹೈಕೋರ್ಟ್ದ ಚೀಫ್ ಜಸ್ಟಿಸ್ ಆಗಿದ್ರಲ್ಲ, ಇಲ್ಲಿ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡ್ತಿದ್ರು, ಯಾರು ಅಲ್ಲೂರು ಇಲ್ಲಿ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡ್ತಿದ್ರಲ್ಲ, ಹಿಯರ್ ರಿಟರ್ನ್ book on lot, but ಅದು ಹೆಂಗ ಆ ಟ್ರಾನ್ಸಿಷನ್ ಹೆಂಗ ಅಗತ್ಯ ಇದೆಯಲ್ಲ, ಈ ಬರ್ಡನ್ ಆಯ್ತಪ್ಪ, ನೀ ಪ್ರೈಮ್ ಫೇಸ್ ಪ್ರೂವ್ ಮಾಡಿದ್ರೆ ಇನ್ಮೇಲೆ ಇವ್ರಿಗೆ ಬರುತ್ತೆ ಅಲ್ಲ, ಆ ಟ್ರಾನ್ಸಿಷನ್ ಕ್ರಿಮಿನಲ್ ಆದಲ್ಲಿ ಇಲ್ಲಿ ಸಿವಿಲ್ ಆದಲ್ಲಿ ಆ ಟ್ರಾನ್ಸಿಷನ್ಸ್ ಮೇಲೆ ಬುಕ್ ಇಲ್ಲ. ನೋ ನಾ ಇಲ್ಲಿ ಟ್ರೈ ಐ ಡು ನಾಟ್, ನಮ್ಗೆ ಸ್ವಲ್ಪ ಬುಕ್ ಟೈಮ್ ಗೇಮ್ ಕೊಟ್ಟರೆ ಬರೀಬಹುದು. ಅದನ್ನು ಮಾಡಿ
BS Malord, the busy Malord. In this.
ಅಲ್ಲ ಇದೆಲ್ಲ ಇವಿಷ್ಟು ಕವರ್ ಆಗ್ತದೆ ತಾನೇ ಮ್ಯಾಟರ್ಸ್ ಇವೆಲ್ಲ ಇದರಲ್ಲಿ.
I am instructed in 5 of these 7 matters.
Same fact matter.
All 5, out of 5, 1 my lords have already
ಮಾಡೇವಿ, ಇನ್ನು ಉಳಿದಿದ್ದವು
ಉಳಿದ 4 also finding on.
ಈಗ ನಾವು ಡಿಸೈಡ್ ಮಾಡೋದು ಯಾವ್ದಾದ್ರು ಮಾಡ್ಬೇಕ್ರಿ?
My lords would have
39.3 ಮುಗಿದಿದೆ.
39.1. 39.1,
39.1,
39.5.
39.5. ಇನ್ನು ಉಳಿದಿದ್ದು ನಿಮ್ ಟೈಮ್ ಬೇಕಾ? ನಾಳೆ ಇಟ್ಕೊಳ್ಳೋಣ.
ನಾಳೆ
ಸುಮಾರು ಹಾಕೊಂಬ
obliged.
ನಾನು ಕಳಿಸ್ತೇನೆ. ಫೈಲ್ ಅನ್ನು ಕಳಿಸ್ಬೇಕು. Okay, thank you so much.
Not only that, even as you would argue, he would make it so pleasant.
Correct.
That is extremely important.
Correct.
So his arguments against us are very pleasant, very
Precise.
precise.
No waste.